the record on too. While I'm waiting for the interpreter to come on the line, how about
Good morning,
appearance?
Your Honor. This is Alan Figueroa, State Certified Spanish Court Interpreter.
Thank you, sir.
Good morning, Judge Kathy Kennedy Swanson on behalf of the Office of State Attorney.
Letitia George on behalf of the Public Defender's Office.
Okay, well, good morning. Okay, let's see. Mr. Interpreter, have you been sworn today?
Yes, Your Honor.
All right. Somebody got you earlier than me, huh?
We have sworn in at 10:15, all of us together with Judge Calderon, Your Honor. That way, whenever we're called, we're done with that.
Okay. Let's see. I'll pull my paperwork here. Let's see. Okay, first case number is, thinking, well, let me see. What's your name?
Camacho Moreno. Camacho Moreno.
Oh,
Camacho Moreno.
all right. So this is case number 2020 CF 8574. Mr. Marrero, you're being held on a capias that was issued for your failure to appear at a trial management conference on, looks like, November 30th of last year. And then you picked up a new charge at the same time in 2021 CF 253. That's possession of MDA and resisting an officer with violence, both of which are felonies. So let's see here. It looks like, based on the affidavit of insolvency that you filed, that you do qualify for the public defender. So do you understand all of that, sir?
Yeah, sí.
Yes.
Okay. Well, on the failure to appear, that court has ordered that you be held no bond. That's Division 11. That's on the possession of cocaine charge. And then on the new cases, possession of MDMA, finding probable cause for that charge, I'll set your bond at $1,000. As to the resisting with violence, I'll set an additional bond at $150. Now, do you understand I've appointed the
Yo no
public
tengo chavo
defender
firme,
for you?
tampoco. Yo soy hijo, yo vivo en la calle.
I don't have any money for a bond. I'm homeless.
Well, I understand, but that failure to appear, you're going to have to address that before the court in Division 11. That's the court that you failed to appear in front of. So money for a bond or not, you're not going anywhere until that court orders otherwise. So you understand I've appointed the Office of the Public Defender for you?
Yeah.
Yes.
Okay, well, that's who you're going to want to talk to now as your attorney about possibly getting a bond hearing, okay? Good luck, sir. Thank you. This one?
Yes, and I'll check.
Sure. You betcha.
Thank you.
What's your name?
Miguel Antonio Vélez Mercado.
Miguel Antonio Vélez Mercado.
All right, sir. In case number 2021 CF 252, you're charged with possession of a firearm in the commission of a felony and possession of cocaine. Do you understand those charges?
No contest.
No contest.
I didn't hear the response.
No contest.
You say no contest? He didn't say that. Did he say that? Do you understand what you're charged with, sir?
Oh, sí, yeah. Yeah.
Oh, yes. Yes.
Okay, well, I've reviewed the affidavit. I do find probable cause for the charges. Now, you do qualify for the office of the public defender to be appointed. You also qualify for pre-trial release. Do you understand that?
Sí, señor.
Yes, sir.
All right. State any objection to PTR in this case?
Let me have a moment, Your Honor.
Sure.
No objection, Your Honor.
All right, I'm going to authorize your release, pre-trial release, as to the 2 charges. And you're going to be ordered to consume no alcohol or drugs as a condition of your release. PTR will be testing you periodically to make sure you're complying with that court order. You're also ordered to have no weapons on or about your person as a condition of release. Any weapons that you own or regularly have in your possession, you're ordered to turn over to the Orange County Sheriff's Department within 24 hours of your release. So, any questions that you have at this point, you're going to want to ask your attorney, which at this point is the Office of the Public Defender. And with that, I'll conclude the hearing. Good luck, sir.
Gracias, honor. Have a good
Thank
day.
you.
Plus pre-trial release, so are you ready? I mean, our pre-trial release with our release.
Yeah.
Okay.
Yeah, before there.
I believe that's our last interpretation.
I think it is, Mr. Interpreter. I think that's all we got.
Thank you, Your Honor.
Listen, have a good day. Have a good weekend.
You as well, Your Honor.
Do you have a Roscoe Aguilar?
I pulled it out.
You pulled it out.
Roscoe Aguilar?
You don't have it.
We don't have it.
The next one.
You know, I was looking for a Tiffany Stone.
She's gonna be behavior, Your Honor.
Behavior?
Yes, sir.
Okay, well, let's talk about Tiffany Stone, shall we? I see that the PD was appointed for back in, when was that? There's a date there somewhere.
Second page at the bottom.
Yep, there it is, July 24th. She was, she had an out-of-county warrant out of some county that's not Orange County. And she had a $2,000 bond. And apparently Corrections has communicated on a couple of different occasions with whatever county that is. What county is it? Which one? DeSoto?
Yeah.
Okay, DeSoto County. And they haven't attempted to do anything to try and come pick her up. So my question for Corrections, is she being held on anything other than that warrant?
No, Your Honor.
Okay, my inclination at this point, I think we've given DeSoto County plenty of time to do something, maybe just respond, and apparently they haven't done that. So at this time, I'm going to direct that as to this charge, and we cautioned them about this. Corrections sent them a teletype saying she could be ROR'd on this date if they didn't do something, and I assume that as of this date, Corrections, you've heard nothing from DeSoto County?
One moment. No, Your Honor.
Okay, so at this time, I'm proposing to ROR her on the charge. And, you know, I'll just treat her failure to come up today as a voluntary waiver of her right to appear, but my inclination is to ROR her anyway, on this charge only.
On both cases?
They both out of DeSoto County?
Yes, Your Honor.
Yeah, both cases. So, there you go. But she apparently has some ongoing mental health issues, or she's just
I believe so.
yeah, okay. Well, I think that's the right thing to do, so call it a day with that. All right, next case number is 2021 CF 297. What's your name, sir?
Ramphis.
You say it a little louder.
Ramphis.
Last name?
Oh, full name? I'm sorry. Ramphis LeBoy Kendall.
Yeah. Yeah, we're occasionally on a first name basis around here, but not very often. Only for people that only have one name.
I'm sorry.
You're charged with battery by strangulation and tampering with a witness. Both are filed as felonies. Both are alleged to be domestic related. And having reviewed the affidavit, I do find probable cause for the charges. It appears that you qualify for the public defender. So would you like for me to appoint the public defender to represent you?
Sir, please.
All right, I'll do that. And let's see, as to the battery by strangulation, I'll set your bond at $2,500 on the tampering with a witness at $150. Now, you're going to be ordered to have no contact with the victim in this case. That's a condition of release. You're to maintain a separate residence from the victim. You and the victim live together, correct? All right. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. As an additional condition of release, any weapons that you own or regularly have access to, you're ordered to turn over to the Orange County Sheriff's Department within 24 hours of your release. Now, having said all of that, I'm going to authorize you to go back to the residence one time in the company of a law enforcement officer to recover your personal effects. Other than that, the no contact order is solid and remains in effect until the court orders otherwise. Do you understand?
Yes, sir.
All right. Now, you're represented by the Office of the Public Defender. If you have any questions, you want to direct them to your attorney. All right?
Thank you.
Good luck.
Or the bond amounts.
2,500 for the first.
Thank you. And 150. Thanks. Yep.
Hey, you ever have this happen? I asked my daughter to pick up some things for me at the store the other day, specifically at the Walmart. Family Market, what they call it. And then I didn't think about it, and a day or two later I was looking for the things that she had to pick up, and I said, well, what did you do with those? And she said, well, I just laid them right there on the counter. I said, okay, and so we looked and looked and looked. Apparently somebody picked it all up and threw it away.
Oh.
That was a little odd,
Right.
but, so, good morning there.
Hello, how are
Madam.
you?
I'm good, how are you?
Good, my approach?
Come on up. Had a good week?
Yeah, not too bad. How's yours?
It's been interesting, sitting here doing this. Sort of a flash from the past, you know?
Got to your groove now? And now that you're done?
Yeah. It took a couple of days for me to get back into the swing of things.
Uh-huh.
And,
Sure.
you know, it's like riding a bicycle. A little wobbly at first, but eventually I straightened out. Yeah, I'm back downtown next week.
Traffic, Bobby
Yeah,
Gibbs.
no, I'm.
Do an injunction return. So it's the same thing we do here,
Is
just
arresting a new
civil.
one. He has an out on bond.
And believe me, people there are
I'm
anything
not gonna,
but
I'm
civil.
gonna make I'm not gonna do that. I don't have no objection to RORs, and then on the KPS, it's $500. But please help
They
me.
get, and now doing it
Not
virtually,
And trying to
they
use
they
license
feel
so
like they
that-
can just do or say
we
whatever they
clean out all
want.
three,
And I
get them
tell them up
individualized
front,
right
look,
now, so.
I got a button here. And if you get out of line or you won't, follow the rules for the hearing, I'll just hit the button and I'll mute you. And if muting you doesn't do any good, eventually I'll just totally eliminate you from this. And occasionally I have to do that. I've done it with a couple of lawyers. Well, yeah, they just, wouldn't be quiet. They wouldn't let me do what I needed to do, and so, I said, okay, well, I guess you really didn't want to be in this hearing, did you? You still living out there in my neck of the woods? No?
No, when I divorced my ex-husband, I lived up on the east side for a while. Now
So many felonies.
Right.
Now I'm down in St. Clair. I got remarried and I'm down in St. Clair.
No, okay, well, congratulations for the divorce and getting remarried.
Oh. Well, I was divorced when you were still. No, when
I don't think you, I don't remember you ever saying that.
No, because I think I was probably still living out Christmas when we were out
Yep.
here.
Sure were. Living in the promised land, you moved away from it.
Well, my two youngest kids still live out that way, so I still out that way.
It was good, if you supported the wrong person for the presidential election to not be living in Christmas.
Well, yeah, I think the last week, I bet my daughter, she was out trucker or something.
Yeah. Well, not only that, but eventually she managed to acquire this great big Joe Biden flag, and she stuck it out front. And I said, that's cause out here for people to do a drive-by at our house. And she goes, oh, they wouldn't do that. I said, well, I don't know. But she still got it up. She said she's not taking it down until he gets sworn in. And my next door neighbor is even worse. I mean, he's got it plastered all over the front of his property. And I just keep telling the two of them, when they come for you, I've only got X number of things I can do to protect you, most of which would be run and hide. And so you guys need to be aware that if they come for you, I'm going to say, hey, I was a loyal supporter of the other guy. I'll lie. Listen, be careful. Oh, yeah. Yeah, I'll be back. Is it? Okay. I should stick my head in down there and say hello when I'm there next week. But moving around down there is kind of tricky. People get a little sensitive about it. So I might be able to stick my head in there.
Yeah, I'm down in the warrants office right next to the church.
Okay. Yeah.
You gotta stick your head in there or shoot me an email or something and we'll meet halfway in between. 'Cause you're on the
All right.
you're on the third floor, right?
No, 16th.
Oh, 16. There's an
Yeah.
elevator. I move around.
Yeah. Once I get up there, I'm sort of trapped for the period that I'm there, but I get periods where I'm in between. So if I can, I'll stop down there. Be careful.
All right, take it
Be
easy.
safe.
You as well.
Me too.
Let's see, next case number is 2020 CF 14759. And what's your name, sir?
David Perez.
It's what?
David Perez.
Okay, how about James Cutliff?
He's on his way, Your Honor.
Okay, I'll just lay him off to one side.
Different list for us.
All right. And, okay, Mr. Perez, the case number for you is 2021 CF 264. The charge is battery by strangulation, which is a felony. You are qualified for the public defender. Do you want me to appoint the PD for you? Yes?
Yes, please.
Okay. I'll appoint the public defender to represent you. I did read the charging affidavit, and I do find probable cause. There was one line in the charging affidavit that particularly caught my attention. Perez was arrested last year in March for battery by strangulation and another previous incident which occurred in Volusia County. So that always catches your attention when you're looking at one of these things.
May I say something?
I also see that you're on federal probation.
Yes, sir.
So you really want to be wary of saying anything in here
Yes, sir.
because it could impact you not only in this case, it could impact your probation.
Yes, sir.
You got a lawyer, you should talk to your lawyer before you say anything out loud.
Yes, sir.
All right? So as to the battery by strangulation, I found probable cause. I'm going to set your bond at $5,000. You're going to be ordered to have no contact with the victim. You're to maintain a separate residence from the victim. You're to consume no alcohol, no drugs, not prescribed for you by your own physician. You're to have no weapons on or about your person, any weapons that you own or regularly have access to. You're ordered to surrender to the Orange County Sheriff's Department within 24 hours of your release. So corrections, is there a hold from his federal probation?
No, Your Honor.
Okay, that's probably going to be coming through, but that's something you need to talk to your lawyer about, okay? All right? Good luck. Either one of y'all watch that series on one of the channels, The Spanish Princess? No. I know it. You look at me and go, you're watching The Spanish Princess?
Right.
Yeah, I have to. My wife watches this. I'm in the room, I watch it. It's interesting. It's about a young King Henry VIII and his first wife, who he ultimately divorced, but in order to divorce, he had to pull England, Britain, out of the Catholic Church and start their own church. But you talk about a wacko dude. This guy.
The non-payable Garner.
He was something.
I guess I missed the comment.
So what's your name, sir?
You want to reach out to your account?
My name is Kyle Rampersad.
All right, Mr. Rampersad. You are, well, case number is 2021 CF 228. The charge is, you got 3 counts of battery. This is pursuant to a capias that was issued, a probable cause order. And
There's only one non-payable.
where's warrant served? The bonds are set at $500 each. They are delineated as domestic violence batteries, so let me see what I got here. Who the heck signed this? In addition to the bonds, the probable cause order orders that you're to have no contact directly or indirectly with the victim, any co-defendants, and any witnesses in the case. You're also ordered to maintain a separate residence from the victim in the case. You're not to return to the scene of the offense. You're not to possess or consume any alcohol or illegal drugs or any controlled substances without a valid prescription. You're not to possess any weapons or firearms. I'm adding to that firearms stipulation that if you own or regularly have access to any weapons or firearms, you're ordered to turn them over to the Orange County Sheriff's Department within 24 hours of your release from custody. And what is your plan as far as an attorney is concerned? Are you going to talk to a private attorney?
No,
What do you plan to do for an attorney, sir?
I was supposed to have one, but I forgot to say.
When you say you're supposed to have one, is that a private attorney or a public
A
defender?
public defender.
So, do you work?
No. No.
Huh?
No.
Do Do you receive money from SSI or Social Security Disability or any kind of a former job?
No,
Is that no?
no.
What it sounds like he's saying. Okay, I'll take that as a no. So why don't I go ahead and appoint the public defender for you, at least temporarily. And then you're going to fill out an affidavit of insolvency for us so that we can see if you actually qualify, okay? Any questions you have, you want to direct to your attorney, sir. Understand?
Yes.
Good luck. Thank you. I just a little bit of an issue there. Not a huge one, but an issue. Next case is 2021 CF 298. What's your name, sir?
Jerome Roll.
Roll?
Yes, sir.
All right, sir, you are charged with criminal mischief with a weapon, and I believe that was a box cutter, and then battery as an incident of dating violence. According to the affidavit you filled out, you don't qualify for the public defender, so I suspect you'll be talking to a private attorney.
How? Sir, I discharged what I have. I haven't done it.
I can't hear you.
Discharge what I have. I haven't done it.
I would advise
I have my
him
own-
not to say anything.
Yeah, you really don't want to start talking about that at this point. What we're talking about is your conditions of release. And so when you start talking about the facts of the case, you put yourself in jeopardy of saying something that could be used against you.
Okay.
And you do have the right to remain silent.
Okay.
And if you say something that could be used against you, the state attorney's going to write it down over there, and I guarantee it'll come back to bite you.
Okay.
So you're going to have to talk to a private attorney in order to get counsel based on the affidavit that you filed. You may want to consider filing an amended affidavit if it would be correct to do so, to see if, in fact, you do really qualify. In the meantime, you do qualify for PTR, but I don't have a victim. So without a victim, I can't do a non-monetary form of release. What I'll do on the criminal mischief with the weapon, I'll set your bond at $1,000. And then on the dating violence battery, I'll set your bond at $150. I am going to order that you have no contact with the victim. You're going to maintain a separate residence from the victim, consume no alcohol, no drugs not prescribed for you by your own physician, have no weapons on or about your person. Any weapons you own, you're to surrender to the Orange County Sheriff's Department within 24 hours of your release. And I believe that'll do it. Although I'm reluctant to do this, but
I want to get back to my job.
if you have any questions at this point,
Yes.
you can ask the question. I can't guarantee I can answer it, but go ahead.
She have my house keys.
She what?
The victim have my house keys, and she doesn't live there. So
Well, I'm
how-
not ordering you not to return. I'm ordering you to have no contact with the victim.
But how can I be able
If
to
she,
get?
meaning if she's not there, then there's nothing wrong with you going there.
But I
if
mean,
she's there-
how can I get my keys? Because she have my keys to my car and everything like that, to the apartment, everything. How can I get it from her
Well,
without me having
is
to
she
call?
there or not?
I don't know. I cannot say. She have her own apartment. That's my apartment.
Okay.
Can we do a one-time return with
Yeah,
law
I don't
enforcement
mind
if-
doing a one-time return.
Yeah.
If she's not there, let me stress this again to you.
I know that.
I'm ordering you to have no contact with her. If she's not there and she doesn't live there, then there's nothing to stop you from going back there. If in fact she's still there, or if you have stuff at her apartment, you're allowed one trip back to either place in the company of a law enforcement officer
okay.
to recover your personal effects.
Yes, sir.
So, we
Yes, sir.
clear on that?
Yeah, I clear on that.
Okay, well, good
Yes, sir.
luck.
I just don't want to get in trouble and get back in
Yeah, I
jail
don't want you
again.
to get in trouble either.
All right, thank you, sir.
You're welcome, sir. And let's see, what's your name, sir?
Jeff Soskin.
Okay. Case number is 2021 CF 284. And the charge is aggravated assault with a firearm, which is a felony. I am going to find probable cause. It's a pretty brief affidavit, but I believe there is probable cause in the affidavit
Can you explain that to
for
me,
the
sir?
charge. I'm also, let me tell you, you qualify for the public defender. Do you want me to appoint the public defender for you?
Yes, sir.
All right, I'll do that. And this place where this alleged incident occurred, this is where you live,
Yes, sir.
and your brother lives there too?
Yes, sir.
Okay. Well, it's pretty simple based on that. I can't let you go non-monetarily because I have no victim out there to tell me that's okay. And so what I'm going to do is set your bond at $2,500, order that you not return to the scene of the offense, that you are to have no contact with the victim, you're to maintain a separate residence from the victim, consume no alcohol or drugs not prescribed for you by your own physician, you're to have no weapons on or about your person, any weapons that you own or regularly have access to, you're to turn over to the Orange County Sheriff's Department within 24 hours of your release. And I'm going to authorize one trip by you back to the property in the company of a law enforcement officer so that you can recover your personal effects, because you're not going to be living there for the immediate future. We clear?
Yes, sir.
Any questions you have, you want to direct those to your attorney, sir. Good luck. Good morning. Your name?
My name's Andre Vives.
All right, Vives, Andres Vives. Sir, the case number is 2021 CF 299. The charge is tampering with a witness to hinder communication to law enforcement, and there's also a battery that's alleged to be an incident of domestic violence. Having reviewed the affidavit, I do find probable cause for the charges. Also, from your affidavit of insolvency, I note you qualify for the public defender. Would you like for me to appoint the public defender to represent you?
Yes, sir. Yes, sir.
All right, I'll do that. As to the tampering charge, your bond will be set at $1,000. On the battery charge, it'll be an additional $150. Now, you're going to be ordered to have no contact with the victim or any witnesses in the case. You're to maintain a separate residence from the victim. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. Any weapons you own or regularly have access to, you're ordered to turn over to the Orange County Sheriff's Department within 24 hours of your release. Now, you live with the victim, right?
No, sir.
No? You have stuff there that you need to get? So you have no reason to go back to that location?
Not at all.
So no return to the scene of the offense? And
No, sir.
any questions you have, you want to direct those to your attorney, sir.
Thank you.
Good luck. And what's your name, sir?
Cristian Angueira.
Say it again.
Cristian Angueira.
Okay.
No, I'm good.
Well, the charge is battery. In case 2021 MM155. And it's charged as a misdemeanor domestic battery. Now, you do qualify for the public defender. Do you understand that, based on your affidavit?
Yes, sir.
Do you want me to appoint the public defender?
Yes, sir.
Okay, I'll do that. And Let me just indicate the following. In reading this affidavit, I have an issue with probable cause. The victim claims not to know how she got the bump on her head, and there's no real PC in there anywhere, or at least I'm not seeing it. So,
State will request 24 hours, but no objection to setting a bond.
I didn't hear you.
State requests 24 hours for PC, but we have no objection to setting a bond.
Okay. Well, I can do one of two things. I could give the state 24 hours to supplement the record to see if probable cause exists in your case, or I can simply set a bond for you at this point, and that way you can bond out. But it's going to be with conditions. You understand? Then that will be, we'll set a minimal bond of $500. And I am going to order that you have no contact with the victim, that you maintain a separate residence from the victim, that you consume no alcohol or drugs that are not prescribed for you by your own physician, and that you have no weapons on or about your person. You're ordered to turn over any weapons you own or have access to regularly to the Sheriff's Department within 24 hours of release. So, do you understand all that? I mean, it's a lot of stuff that I say. And is there any part of that you don't understand?
I understand everything, sir.
Huh?
I understand everything, sir.
Okay. So if you have any questions, you're going to want to direct them to your attorney.
Yes, sir.
That's the public defender, right?
All right.
Okay. Well, good luck. No PC. Not that that matters. I mean, realistically, it's just a matter of whether or not, you're going to let them go under some other circumstance. So, good morning. What's your name?
Naeem Clark.
All right, Mr. Clark, in 2021 MM153, you're charged with battery as an incident of domestic violence, which is a misdemeanor. Do you understand that charge?
Yes, sir.
All right. Your affidavit of insolvency indicates that you don't qualify for the public defender. You make too much money. Yeah, these numbers really need to be updated, though. But right now, you don't qualify.
Okay.
So if you're going to have an attorney, you're going to have to hire a private one, right?
Okay.
I'm going to put you down as you're going to get your own attorney. I'm also going to indicate that I do find probable cause for the charge or charges. Bond is going to be set at $500. Now, you're going to be ordered to have no contact with the victim as a condition of release. You're to maintain a separate residence from the victim. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person as a condition of release. Now, were you living there with the victim?
It's my apartment, Your Honor.
Well, is the victim living there?
Yeah, she living there.
Okay, well, it doesn't matter whose apartment it is. As long as she's there, you can't go there.
I understand.
Now, what I will do is authorize you to make one trip back in the company of a law enforcement officer to recover your personal effects. So, understand all that?
Yes, sir.
All right, any questions?
No.
Good luck.
All right.
Thank
Sorry, Your
you.
Honor, what was the bond amount?
$500.
Thank you.
Good morning. What's your name?
Richard Gray.
Okay, you got a bunch of aliases here, Mr. Gray. One of them is Richard Corey.
I think that's from my son. I never used aliases, sir.
Well, it's just incidental because, how old are you?
I'm 57 in
Okay.
June.
So potentially you remember Simon and Garfunkel?
Yes, sir.
You ever heard that song, Richard Corey?
Yes.
Okay, is that where it comes from?
No, I don't know. I didn't make it up. That's what I'm saying. I don't know where that comes from.
Oh, yeah, Well,
I saw that today when they did it. I don't know. I've never used aliases.
Okay, well, the case number is 2021 MM167. See, now I got that song running through my head. I'm going to break out into a rendition of Richard Corey by Simon and Garfunkel any moment.
I know Little Richard, Open the Door Richard. That's what it
Little Richard? Yep, we're telling people how old we are by saying that. The charges are, there's a battery charge and an assault charge. And you do qualify for the public defender. Would you like for me to appoint the PD for you?
Of course, sir.
Okay. Finding probable cause for the charges, I'll set your bond on the battery charge at $500 and then $100 on the assault charge. Now, you're going to be ordered to have no contact with the victim or victims as a condition of release. Also, no contact with any witnesses as a condition of release. You're to maintain a separate residence from the victim. You and the victim were living together, is that correct?
Actually, that night she was leaving.
Okay, well, as long as she's there, you can't go there.
I understand.
But if she's there and you can't go there, I'll authorize one trip back in the company of a law enforcement officer for you to recover your personal effects.
Okay.
You're also going to be ordered to consume no alcohol or drugs not prescribed for you by your own physician, and you're to have no weapons on or about your person. Any weapons you own or regularly have access to, you're ordered to turn over to the Orange County Sheriff's Department within 24 hours of your release.
Yes, sir.
So, clear on all that?
Yes, sir.
Now, you understand I appointed the PD, so if you have any questions, you want to talk to your attorney about it, okay?
Okay.
Good luck, sir.
Thank you, sir.
You are welcome, sir. Good morning. Your name?
Good morning. My name is Christopher Irizarry.
All right, Mr. Irizarry. Let's see what we got here. 2020 MM178. You got a charge of violation of a domestic violence injunction. Which I do find probable cause for. And I've got a copy of the injunction here. And let's see, you did file an affidavit of insolvency. You do qualify for the public defender. Would you like for me to appoint the PD for you?
Yes.
Okay, I'll appoint the public defender for you. As to the new charge, violation of a domestic injunction, your bond is going to be set at $2,500. You're going to be ordered to strictly comply with all terms of the injunction as a condition of your release. No contact with the victim, maintain a separate residence from the victim, consume no alcohol or drugs not prescribed for you by your own physician, and I'm going to make PTR also a condition. You're going to be under pretrial release in addition to the bond. So they're going to monitor you. They're going to test you to make sure you're not doing any drugs or alcohol. And you're to have no weapons on or about your person as a condition of release. Now, you're also out on bond on an aggravated stalking after an injunction with the same victim. Your bond on that is $2,500. I'm revoking that bond, and I'm going to order you held no bond on that case, pending further order of the court where the case is pending, which is, well, I don't know what division that's in, but one of the cases downtown.
Division 15.
15, Division 15. So while you have a bond on the new charge and PTR, you're no bonded as to the case you were out on bond on, pending further order of the court in Division 15. Now, do you understand all that?
So basically, I'm allowed to be bonded for this right now, but not bonded for the...
Yeah, for the other one, your bond is revoked.
So I'm basically not going anywhere.
Right. You'll be here until further order of the court in Division 15.
The attorney on that case can
outside, and we could talk about trying to move forward with the bond motion.
PTO.
It might be
Yep.
highly unlikely in your case.
I don't even know what RUA means, but
We
yeah,
have to
I'll
take care
order
of that
that.
downtown.
Well, I think they're doing it again now. So, yeah. I like that.
No judgment. We get a bond, can't be a high one.
Good morning. What's your name?
Evelyn Moreno.
All right, Ms. Moreno, in 2021 MM175, you are charged with battery. It's a misdemeanor domestic battery. I did review the charging affidavit. I do find probable cause for the charge. You also qualify for the services of the public defender. Do you want me to appoint the public defender for you?
Yes, please.
Yes, okay. I'll do that. Having found probable cause on the new charge, or on the charge of battery, I'll set your bond at $500. You're going to be ordered to have no contact with the victim. You're to maintain a separate residence from the victim. I'm going to order that you consume no alcohol or drugs not prescribed for you by your own physician. You're also to have no weapons on or about your person. Any weapons you own or regularly have access to, I'm ordering you to turn over to the Orange County Sheriff's Department within 24 hours of your release from jail. So there's a couple of things there you need to understand. The public defender is your attorney, your best friend as of this date, and any questions you have, you need to direct to your attorney, and you're not allowed to go back. Now, you were living there, is that correct?
Yes.
Okay. I'm going to let you go back one time in the company of a law enforcement officer to recover your personal effects. So, do you understand all that?
Okay, so if I'm living with my daughter, we cannot be in the same residence?
Yeah, you can't until further order of the court. For now, you can't go back there.
Okay.
Other than just to pick up your stuff, and you have to have a cop with you when you go and do that. You understand?
Okay.
All right. Well, good luck.
Thank you.
What was the bond amount? Oh, sorry.
$500.
Thank you, Your Honor.
I didn't say 500?
You may have, that's.
It's a special skill I have. As soon as the words leave my mouth, they also leave my brain. Which is a good way to survive in the world.
I guess.
Well, you know, you get that stuff that you get on your mind and you can't get rid of it. Can't go to sleep at night, can't do stuff like that. I don't generally have that problem. It's probably a sign of early onset dementia. But what am I going to do? Okay. Step on up there. What's your name?
Brian Rosa.
Oh, yeah, okay.
Valencia is medical, Your Honor.
Medical?
Yes.
So, well, given the nature of the charge, it being a domestic battery, it might behoove us to reset that for tomorrow. What do you think?
I'll leave that to the defense, Your Honor.
You good?
Yeah, he was going. Your Honor,
We do know that before she's released, if we decide to do it without her present, that they will get a no contact order signed by her.
Right.
yeah, I would just waive her appearance because tomorrow is gonna be the weekend. Yeah, I have to waive her appearance, Your Honor.
Well, I understand. The only reason I said that is because I guess there's a possibility the victim might show up, and she does qualify for PTR, which is not going to happen today without a victim. But yeah, I can set a bond and conditions if you want to stick with a waiver. So
I would just set a bond, Your Honor, because I don't believe she's gonna qualify for a pretrial release because we're talking about Brian Rosen, am I correct?
Alyssa Palencia.
Yeah, is that who? No.
No,
Is that who we're
Palencia.
talking? We're talking about Brian Ruzan.
Yeah.
Oh,
I'm sorry.
No, we're talking about,
I'm sorry, I was looking at another paper.
Alyssa.
He doesn't qualify for PTR.
Oh, Alyssa Palencia,
No, we were talking about her.
No, we were talking about her.
Yeah.
She's medical, yes.
Yeah, she's medical, that's right, I got confused.
oh, so, Miss Palencia is medical.
Yes.
So that means she probably won't be back here for like another week or so, Your Honor.
No. Her medical is something else.
Yes.
Oh, so we could roll it?
She's pregnant.
Oh, she's pregnant.
And I would set a bond.
Yeah, Your Honor, I'll waive it to set a bond, Your Honor.
So, okay, well, I'll set the bond. I did find probable cause for the charge based on the affidavit. Bond will be set at $500. Ms. Palencia will be ordered not to have contact with the victim, maintain a separate residence from the victim. I'll authorize a one-time trip back in the company of law enforcement to recover personal effects.
Can I ask a quick question, Your Honor?
Yeah.
Are you precluded by law from releasing my client on pretrial release because the alleged victim is not
I
here?
believe I am.
Okay.
I've sort of had that belief for a lot of years based on something I read. And,
Your Honor, just for the record, I would ask, because of the special circumstance that my client is pregnant and being in the jail, especially and with the oncoming pandemic, there may be some jeopardy to her unborn child. And for the unborn child's sake, not the sake of my client, I would ask the court to consider a not pre-child release, an ROR in this matter. It is a battery, but it is a misdemeanor, and she has no criminal history, no arrest. This appears to be a first offense. And it's been my experience in the past that other judges have released clients on non-release conditions during DV matters for special circumstances.
I understand what you're saying, and I appreciate the argument, but I don't believe I can do that.
Okay,
I believe that's not authorized by law unless we have a victim to consent to it, either through corrections or by being here directly. So again, I appreciate it all. I respect your argument, but I believe I have to set a bond. So I'll set a minimal bond of $500.
Thank you, Your Honor.
And order no contact and maintain separate residence. No alcohol or drugs not prescribed by her own physician. No weapons on or about her person as a condition of release. So at least she can bond and get out of here. So you're Brian Ruzon, right?
Yes, sir.
All right, Mr. Ruzon. Interesting. In 2021 MM 169, you're charged with battery. It's a charge as a misdemeanor, domestic battery. You do qualify for the public defender, and so you want me to appoint the PD for you? Yes?
Yes, sir.
Okay. I'll appoint the public defender for you.
My dad said he was supposed to come down here. That's from him. But
What?
My dad, he was the one who intentionally called, but he said he was supposed to come and drop it.
Well, as you can see, he's not here.
Yeah.
So, but you got bigger fish in the pan than just this battery case.
Yeah,
On the
that's
battery
right.
case, your dad not being here and the court not hearing from the victim, I'm going to set your bond at $500. You're ordered to have no contact with the victim, maintain a separate residence from the victim.
I do.
Consume no alcohol, no drugs not prescribed for you by your own physician. Have no weapons on or about your person. Any weapons you own or regularly have access to, you're ordered to turn over to the Orange County Sheriff's Department within 24 hours of your release. Now, 11/10/2020, aggravated fleeing and eluding with injury and damage, driving while license suspended, aggravated assault on a law enforcement officer with a motor vehicle, and resisting without violence. You got a total of $9,000 in bonds in that case. Those cases are pending in Division 12.
Yes, that's a 28.
Well, I'm revoking your bonds on those. I'm going
Okay.
to order you held no bond on the stuff you're out on bond on, pending.
I got a court date already for those on 28.
Pending further word from the court in Division 12. So for now, revoked, no bond, as to those charges that you're out on bond on?
No, that's what I was saying. I have a court date set for those, sir.
Well, okay. But you're gonna have to talk to your lawyer about that, because I'm gonna leave it at no bond on that. Good luck.
So I could bond out on this charge, but not on that one.
Right.
Okay.
You're welcome.
Oh, yes, sir.
Your name, sir?
I'm Robert Winstead, sir. Or Your Honor, I'm sorry.
Robert Winstead. Jaded. Well, let's see, Mr. Winstead, in 2021 MM173, you're charged with battery. It's alleged to be an incident of domestic violence. It is charged as a misdemeanor battery. Now, you do qualify for the public defender. Do you want me to appoint the public defender for
I
you?
honestly don't know what I need, Your Honor. It was just a bad night with my dad, really.
Well, unless you're going to hire a private attorney, then appointing the public defender at this point can't do anything but help you. So if you want me to appoint the PD, I'll appoint the PD.
I truly don't know if I should say yes or if it's a misdemeanor. Would I be here another day or two if I do that?
No, it won't keep you here.
Oh, okay, yeah.
Well, that's just getting you a lawyer.
Okay, yes, sir. I'm sorry, I'm not used to this. Yes, sir. I think that would be
understand.
great.
It's confusing. I understand. So I'll go ahead and appoint the public defender for you.
Thank you,
Now,
sir. Thank you, Your Honor.
You know, I said I was appointing the PD, and now I'm looking at the affidavit. You don't really qualify for the PD. So, unappoint PD. What you're gonna need to do is, talk to a private attorney, because you don't really qualify for the public defender, because of your income. So, for now, I'm gonna put you down as to get your own lawyer. Your bond will be set at $500. You're gonna be ordered to have no contact with the victim. You're to maintain a separate residence from the victim. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. Any weapons that you own or regularly have access to, you are ordered to turn over to the Orange County Sheriff's Department within 24 hours of your release. And I'm going to put you down as you're going to get your own lawyer. So do you understand all that?
Yes, sir.
You live with a victim, right?
No, sir. I live very close to him, but I'm from Memphis, Tennessee, and he rode with me, so I don't know how. I'll have to figure that one out.
It's called Greyhound Bus or American Airlines.
Yes, Your Honor.
Okay? So, all right. Good luck. Thank you. Memphis, home of Graceland. You ever been there? No? You call yourself a true American and you've never visited Graceland in Memphis? All true Americans have visited Graceland.
Can you let him in, please? Hold on.
Oh, that's right, I do have a button. Where is it? Is it the big one? Little button up front.
Stay still.
It's a summer button, right? Yeah.
There we go. Because one of those sets off an alarm. I don't want no stinking alarm. So, good morning, sir. Your name?
James Cutler.
Ah, yes, Cutler. And let's see, it's case number 2020 CF 14759. Charge is aggravated battery with a firearm. And I don't see an affidavit of insolvency. Is it your intent to talk to a private lawyer? Can you afford one?
I don't have one.
Do you work?
No, sir.
No, do you have any income of any kind?
No, sir.
Okay, I'm gonna guess that he qualifies for the PD and go ahead and appoint the PD for him. Now, what's your name, sir?
James Cutler.
I'm gonna need you to speak up a little bit.
James Cutler.
Okay, you're his dad.
Yes, sir.
All right, I read the affidavit. The affidavit I do find probable cause for the charge. So, you understand that?
Yes, sir.
Okay. Now, as the victim in the case, you have a right to talk to me about what conditions you might like to see for him as far as release is concerned. So, raise your right hand. Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. We'll start with, he qualifies for pretrial release, which is a non-monetary form of release.
Yes, sir.
Do you understand that?
Yes, sir.
What are your thoughts about that? Are you still afraid of him?
No, sir. He's
No?
back at our residence. Everything was okay. I didn't know they was gonna come back and pick him up.
No. Well, if he gets out of jail on pretrial release, do what are your thoughts about him coming back to your house?
I don't mind him coming back because he has nowhere else to go. So I'm not afraid of anything
So
happening.
you're good with all that?
Yes, sir.
Okay. Well, what I can do is I can release him pretrial release.
Yes, sir.
Was there alcohol or drugs involved in this?
We both had a couple of drinks.
So he was drinking.
Both of us.
Yeah, but you're not the defendant. You're free to drink all you want. He's not.
Well, we had a few drinks, not too many. Just had a misunderstanding.
No drugs that you know of.
No drugs.
But alcohol? Okay, I'm going to release him pretrial release.
Yes, sir.
Now, I am going to order that he's to have no hostile contact with you.
Yes,
no
sir.
more fighting.
Yes, sir.
Also, that he's to consume no alcohol, no drugs, not prescribed for him by his own physician, and that he's to have no weapons on or about his person.
Yes, sir.
And if he owns or has access to weapons on a regular basis, he's ordered to turn those over to the Orange County Sheriff's Department within 24 hours of his release.
Yes, sir.
So, does all that make sense to you?
Yes, sir.
And you're comfortable with me ordering that?
Yes, sir.
Okay. So, that's going to be it for you, Mr. Cutliff. You're going to get out, but you're going to be on PTR, which means you'll be monitored and randomly tested. So I'm ordering RUAs, which is random urinalysis, to make sure you're not doing any drugs and you're not drinking alcohol. And no more fighting with your dad. You fight, the cops come, you come back to jail. Understand?
Yes, sir.
You understand that I've appointed, or did I appoint the public defender? I don't have an affidavit. I did? Ah, okay. So I've appointed the public defender for you. So any questions you have, you want to direct them to your attorney, sir. Understand?
Yes, sir.
Okay. So, you understand?
Yes, sir.
Any questions?
No, sir.
Good luck. Thanks for being here.
Thank you, sir.
You're welcome. Well, finally got around to a PTR, huh? You know, I saw an email yesterday that would be of interest to y'all, especially because you're going back downtown, right? I believe the email said that jury trials are out of the question through the end of February.
Yeah, I hear till at least February 15th.
Yeah.
Yep.
That's going to be a mess when it finally starts. Okay, let's see. Your name, sir?
Bobby Hicks.
Bobby Higgs. All right, Mr. Higgs. Oh, that's a lot of stuff.
Judge, in Mr. Higgs's case, I spoke to defense earlier. The concern I have is that he has this is third outstanding dual list at the same time. So even if state was to make an offer, this would habitualize him immediately. But maybe Mr. Higgs would like to get his license or get on a payment plan to get a valid license?
I didn't hear you.
I said if I was to make an offer on all of his dual lists at the same time, this would habitualize him. And so maybe Mr. Higgs wants to get on a payment plan to get his license so that he doesn't become a habitualized driver immediately.
So in 2019 CT 141AW, you've got a failure to appear on for a status hearing on a driving while license suspended. That court, when it issued the capias, set your bond at $500. That's in Division 61. And then in Division 62, you picked up another driving while license suspended and failure to register a motor vehicle, both of which are misdemeanors. Presently, the bond set at $500 is to each. My inclination would be stay the count 1 at $500, count 2 set at $100. You do qualify for the public defender, and so you do have the ability to bond on all of this. The danger for you is that if you were to try to resolve these cases today, you would wind up being classified as a habitual traffic offender, and you'd lose your license for 5 years. Not that you have one, but your imaginary license. So having set the bonds on the new stuff and appointed the public defender, I'm going to take no action on the cases that you're out on bond on, because you got a boatload of problems here, but the bonds are as I indicated. So. That's a mess. Did I ever tell you about the time that I was a fairly new judge in traffic court? And they were having a lot of problems with the state giving out bad information on people's driver's licenses, who was suspended, who wasn't. And it was just a real mess. Plus, they were suspending people, and really for no reason. They just mess up and somebody would get suspended. And so Channel 2 came in and wanted to interview one of us about that. And they happened to pick me, and so they were interviewing me about it. And the week before they interviewed me, my wife had gone to the driver's license office to help my middle daughter get her driver's license. And when she produced her license for an ID, they said, by the way, you're suspended. And she was like, why? How could that be? I've never had a ticket or anything. And they said, right here, you've been suspended for like a year.
Yep.
And so we looked into it, and what had happened is my oldest child had wrecked one of our cars, totaled it. And of course, it got towed off to the junkyard and crushed. And somehow the word didn't get to Tallahassee that the vehicle was destroyed. And so they suspended her license, not mine, but hers, because as far as they were concerned, they were showing that she lacked insurance on the vehicle. And I told Channel 2 that, ooh, you talk about that reporter getting excited. Oh, they were jumping up and down because this was making their day.
Yeah.
And
That happened to my stepdaughter last week.
Did it?
It had, yep, her license was suspended for lack of insurance, and yet she went to the DMV with a letter, and they were like, it's not valid. The letter's dated today. And it's like, yeah, but if you read the body of the letter, it tells you that it was active. It's never been lapsed. You can't just look at the top date, because the top date is today's date, obviously.
Oh, yeah. It almost makes you want to check everybody you know's status.
I do.
Every chance you get.
I do. Me and Alicia, we do that. Our spouses, you have to, just because.
I just told my family, including my wife, that they're on their own. Don't come to me with any problem like that.
One way to do it. One way.
Go on down there and solve it yourself.
I like it.
Because every time I think DMV, I think of them two sisters on The Simpsons. And I go, I don't want to go down there and see them. It's terrible, I know, but what am I going to say? So, good morning. What's your name?
Sunita.
Sunita Singh?
Yes.
All right, Ms. Singh, in case 2021 CT 229, you're charged with DUI with a blood alcohol above 0.15 and with a person under 18 in the vehicle. So it's there's some enhancements that are associated with that, not of concern today, but they will be eventually. You also qualify for the public defender. You want me to appoint the PD for you?
Yes. Yes.
Okay. Now, you also qualify for pretrial release. So, I'm going to authorize your release, pretrial release, but there are conditions. They're going to monitor you. You are not to consume any alcohol or drugs that are not prescribed for you by your own physician, and I'm going to order random testing to make sure you're complying with that order. You're also not to drive any motor vehicle without a valid driver's license in the event that that gets suspended. Understand?
Yes.
Any questions?
No.
Okay, good luck. Ooh, look at all that. Let's see, I've got one more. It's Felicia Annette Varnado.
She bonded, Your Honor.
Bonded, okay. Bombing. So, you want to take, how much time do you all need to get the afternoon stuff lined up? Whatever time you need, I'm good with. An hour? Okay. So, why don't we come back about 11:15?
Let's just say 11:30.
Huh?
11:30.
11:30?
Yes, sir.
All right, we'll come back. Y'all good with 11:30 to do the
Yes.
afternoon stuff?
Yes, Your Honor.
All right, State, I know
Yes,
you're
Your
good
Honor.
with it.
I'm good.
You're always good with it. So, okay, 11:30. Okay, records back on. Let's have appearances, please.
Happy Kennedy Swanson on behalf of the Office of State Attorney.
Jace Thompson on behalf of the Office of the Public Defender.
Letitia George on behalf of the Public Defender's Office.
Thank you. Okay, let's see. First case, well, it's Renee Barton.
She bonded, Your Honor.
She bonded, okay. And then Maurice Gilmore. All right, are you Mr. Gilmore?
Yes.
All right,
The offer is a withhold credit for time served, no return.
all right. The charge is trespass on property after warning. And case number is 2021 MM 172. The state has extended an offer if you want to resolve the case today. That would be a withhold of adjudication. You get credit for time served and then be required to pay court costs and not return to, give me just a minute here. Well, that's the Lynx bus station, right? 455 North Garland. So do you understand all that?
Yes.
You think you might like to accept that offer?
Yes.
Pardon me?
Yes.
Okay, would you raise your right hand for me? Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Gilmore, the charge is trespass after warning. The offer is a withhold, time served, no return to the Lynx bus station, and court costs. So, first of all, do you understand the offer?
Yes.
And is that offer something you want to consider or
Yes.
accept?
Yes.
You'll accept it?
Yes.
All right. And you believe it's in your best interest to do that?
Yes.
All right. So, I'll find probable cause, first of all, for the charge. I'll also find that you are freely and voluntarily agreeing to the offer submitted by the state, that you understand the charge or charges that are pending against you today. So I'll accept your plea of guilty or no contest?
Guilty.
No contest.
PD would feel better if you said no contest, but, so I'll take it as a no contest plea. I'll withhold adjudication of guilt, sentence you to time served, and order that you not return to the Lynx bus station for at least a period of 1 year. from today's date, and also that you pay court costs. You suppose you can afford $5 a month?
Yes.
All right, make the court costs payable at $5 a month. First payment due February the 15th, $5 a month thereafter until paid in full. All right. Good luck, sir.
Thank you.
Your Honor, can you advise the defendant that he has reporting requirements?
Oh, yeah. Sorry, Mr. Gilmore. You have reporting requirements. You know, you have to report changes of address.
Excuse me?
You have to report when you change your address.
Right.
Well, this arrest is considered a change of address. So when you get out, you have to report that you were arrested and for the time that you were here. You understand?
Okay. Yes.
Okay, good luck, sir.
Thank you.
Mr. LaPointe, bonded.
Who is that?
LaPointe or LaPointe?
How about Valencia Gardner?
That's right here.
Okay. Good
Your Honor, the offer
morning.
is a withhold credit for time served, no return.
All right, Ms. Gardner, in 2021, you are 2021 MM 171. You're charged with resisting without violence. Do you understand that charge?
No, he said it was petty theft.
No, ma'am. The charge is resisting without violence.
No, Your Honor, she has a
Well, not
failure
this- the
to
paperwork
appear
here says-
warrant. She's on the misdemeanor non-pleables.
Oh,
So I have a petty theft.
Gardner. Or no, that's wrong file. What is that? That's Frickmini LaPointe. You said bonded?
He bonded.
Okay, sorry. Sorry. But see, it had this cover sheet on it.
Yeah, this is what he said he brought me in here for.
So, how that happened?
I know.
Ah, well. It's not the dumbest thing I've done today. Okay, so you're Ms. Gardner. I'm sorry, I had the wrong file in front of me. And you got a failure to appear on a petty theft charge.
No, they transferred me over to the mental health and they dismissed it there. I was transported over, so you should have the paperwork for that. So I'm not guilty of it.
Right, okay. It's a failure to appear for a status hearing on December the 1st on the petty theft charge. The court that issued the capias said that if you qualified, you could be released on mental health pretrial release. And if not, your case is to be set for a bond hearing within 4 days of arrest. The bond at present is set at no bond. So here's the way it's going to work. You're going to be released mental health pretrial release if you qualify.
No, I already been released from there, sir.
If you don't qualify, then you're going to have a bond hearing in Division 63.
Well, you're trying to frame me at that time because I told you I was inside of here. And they already transferred me over to a mental health area that dismissed me out of there. So I don't have any warrant on me at that time.
Okay, so the public defender was previously appointed to represent you on this. So you'll be going out mental health pretrial release, or you'll have a bond hearing within. And if I were y'all, I'd give the Division 63 JA a heads up so she can go ahead and set the bond hearing. Good luck, ma'am. She wouldn't have no part of that, would she? Yeah, stated none. Unless she qualifies for mental health pretrial release. Okay. Mr. Brodus.
Mr. Brodus is mental health, Your Honor.
Oh, rats. I was looking forward to seeing Mr. Brodus. I haven't seen him in a while. Although I did, you know what? I saw him downtown. I'm trying to think of when it was. He was somewhere. It's been a while. But he actually sort of recognized me. Because when I went up and said, "Hey, Mr. Brodus, how you doing?" And he looked at me and I could see the wheels turning. And then he got a good look on his face. Hopefully it was recognition. It could have been something else. I don't know. But So yeah, unfortunately, mental health. So Mr. Brodus is well known to the court, as you all know, and he's charged with disorderly conduct as a city ordinance. My problem is the facts don't support disorderly conduct. They support panhandling. But I don't see.
No objection to ROR. Your
Okay, I'm gonna go ahead and not find PC and direct that he be released on his own recognizance. Be one of the bigger PC issues of the day. Mr. Brodus. Good after late morning, still morning. What's your name, sir?
Steve Bernard.
All right, Mr. Bernard, case number 2019 CF 9126. You have a failure to appear. That's on a sex battery charge. Says you failed to appear for a trial management conference on the 21st of December last year. And that court issued a capias and ordered you held no bond. Now, did he already have the public defender?
I had a conflict attorney, and
Or a conflicts attorney?
yes, Your Honor.
All right.
And I missed that because last time I went to court for that charge, the judge was telling me that he didn't have to set a court date then. He was like, we're going to be on a fluctuating scale because of the pandemic. And I guess I wasn't informed quick enough.
So, I'm going to stay your status in Division 12 at no bond, and your attorney, no doubt, will arrange a time for you to appear before the judge in Division 12 to see about a bond and conditions of release. Good luck.
Marion Blair's hospital, Your Honor.
Marion Blair's in the hospital. What do we got? Now, Marion Blair has some pending out on bond cases.
No objection to no action on the out on bond, but leave the current bond as is.
Yeah, well, so if I go ahead and appoint the public defender for Mr. Blair, you willing to waive his appearance today?
But Your Honor, I believe when they're in the hospital, we reset until 24 hours. Yeah.
Reset it within 24 hours release from hospital?
Yes.
Okay, that makes sense to me. Feel better about that. So, reset within 24 hours of release from the hospital. Good morning. Your name?
Brown.
Dana Dwayne Brown.
Yes, sir.
All right. Mr. Brown, you are charged with, well, this is case number 2021 CF276, possession of methamphetamine and attempted destruction of evidence. Do you understand those charges?
Yes, sir.
And I don't see an affidavit of insolvency here. Is it your intent to talk to a private attorney?
I have it.
Oh, never mind, I got an affidavit. You qualify for the services of the public defender. So, finding probable cause for the charges, your bond on the methamphetamine charge will be $1,000, will be $150 on the attempted destruction of evidence. Understand?
Yes, sir.
Now, I've appointed the PD for you. If you have any questions, you want to direct those to your attorney, sir. Good luck. Your name, please.
Drager Brown.
All right. Let's see. Mr. Brown, in case number 2021 CF246, you are charged with carjacking with a firearm. That case is in Division 12. Do we have a affidavit on him?
No, sir.
Okay. Now that carjacking with a firearm is punishable by life felony. I read the affidavit, charging affidavit. I do find probable cause for the charge. What I don't see here is an affidavit where you are trying to qualify for the public defender. So do you intend to hire a private attorney for this? Do you understand what I'm asking?
Yes, I do. It's just can
I can't hear you though.
I understand. Can I have a word to kind of briefly tell you what's going
You
on?
want to talk to me? That's not a good idea. That's a really not well thought through idea, because anything you say here, if it could be used against you, it would be used against you in prosecuting this crime. So we need to limit what we talk about to, right now, an attorney. So is it your intent to attempt to hire a private attorney?
Yes.
Or would you like to have the court consider appointing the public defender for you?
For this right now, I'd rather have a court consider one.
I didn't hear you.
For this right now, I have a court consider one.
What's a court-appointed one, Your Honor?
Yeah.
Lawyer.
He's asking me to appoint one?
Yes, Your Honor.
Okay. Now, tell me, do you work?
Not anymore.
Okay, do you have any income source at all?
Unemployment.
Unemployment, that's it?
Yes.
All right. Well, I know about that. I'll find that you qualify. I'll appoint the public defender for you. You're presently being held no bond on the charge, so counsel, care to be heard on that?
Your Honor, because of the seriousness of the alleged crime and the fact that he's being held at no bond, the defense will not hold the state to their proof evident presumption grade burden today, and we will reserve the right to have a full author hearing in the trial division.
All right, thank you, sir. That's Division 12, by the way.
Thank you.
You're welcome. So I'm going to stay your status at no bond. You're to have no contact with any co-defendants unless necessitated by the defense of the case, and you're not to have any contact with any victim or victims, no contact with any witnesses in the case, in addition to being held no bond. So, good luck, sir.
No weapons or firearms, Your
Yeah,
Honor.
no weapons or firearms, too. Yep. All right, and your name, sir?
Joshua Dion Cooks.
All right, Mr. Cooks. In 2021 CF 259, you're charged with leaving a scene of a crash with injuries, driving while your license was suspended or revoked as a subsequent offender, and reckless driving as a first offense. Do you understand those charges?
Yes.
All right, you said? Yes, the PD affidavit. Well, you filed an affidavit, and the affidavit indicates that you qualify for the services of the public defender. Would you like for me to appoint PD for you?
Yes.
All right, I'll do that. Now, I read the affidavit. I do find probable cause for the charges. Your bonds are on the leaving the scene, $2,500, and $100 each on counts 2 and 3. You're ordered not to drive without a valid driver's license as a condition of release in addition to the bond, sir.
Okay.
So you understand I've appointed a PD for you?
Yes.
All right, any questions you have, you want to direct to your lawyer.
Okay.
Thank you. Good luck. And let me see now, what's your name, sir?
Paul Cross.
All right, Mr. Cross, in 2020 CF 14520AO, I have a warrant here charging you with failure to register as a sex offender. And probable cause was found by the judge who signed the warrants. Your bond is presently set at 0, but the judge who signed that was kind enough to indicate that there was no objection to my modifying the bond at this point. Now, what I read in there was you didn't report in November, and that resulted in the warrant. So, what I'm going to do is I'm going to set your bond at $1,000.
Yes, sir.
You're going to be ordered to report. You have reporting requirements.
Yes, sir.
Not only your monthly requirements, but now that you've been arrested on this, you're obligated to report this arrest as a change of address. Do you understand?
Can you, like...
Same way you report everything else.
Okay, so...
Same place, same way.
Okay.
All right? And, you know what I don't see is an affidavit of insolvency. Is it your intent to talk to a private attorney, or would you like to consider having the PD?
I think my family was planning on getting me a private attorney.
Okay.
Just not 100% sure.
So I'll put you down as you're going to get your own lawyer.
Okay.
And if that turns out not to be the case, you need to let us know so I can consider appointing a lawyer for you, okay?
Yes, sir.
All right, well, good luck. Still morning. Good morning.
Good morning.
What's your name?
Carla Davis.
All right, Ms. Davis, in 2021 CF 272, you're charged with possession of cocaine and possession of drug paraphernalia. Do you understand those charges?
Yes, sir.
All right. You do qualify for pretrial release.
Thank you.
You also qualify for the public defender. So do you want me to appoint the public defender for you?
I'm sorry?
Do you want me to appoint the PD as your attorney?
Yeah, I guess.
Yes?
Am I going to be released? Am I going to pretrial release?
Are you going to pretrial release?
Yes, I don't understand.
Yeah, I'm going to authorize you to go to PTR.
Okay.
So do you want the PD or not?
Yes.
All right. You qualify, so I'll appoint the PD, direct that you be released, pretrial release. Now, that's going to come with stipulations. And one of the stipulations is that you are to consume no alcohol, no drugs. Not prescribed for you by your own physician.
Okay.
And I'm going to direct that PTR randomly test you. So random, what were you calling those, RUAs?
Yes.
RUAs, random urinalysis, to make sure you're in compliance with the court's order.
Okay.
All right?
Okay.
Thank you.
Thank you.
Good morning, sir. What's your name?
Good morning, Damian Delgado.
Mr. Delgado, in 2021 CF 291, you're charged with possession of crystal meth, possession cocaine, and possession of drug paraphernalia. Do you understand those charges?
Yes, sir. Yes, Your Honor.
All right, sir. I read the affidavit. Do find probable cause. Says here you qualify for pretrial release. You also qualify for the public defender. Do you want me to appoint the public defender for you?
Sure. Yes, Your Honor.
All right, I'll do that. And also direct that you be released pretrial release. Now, I am going to direct that pretrial release randomly test you to determine whether or not you're complying with the court's order, which is no alcohol, no drugs not prescribed for you by your own physician.
Yes, Your Honor.
Understand?
Yes, Your Honor.
Okay. There are other things you have to comply with PTR. They'll explain those to you.
Yes, Your Honor.
Thank you. Good luck.
Thank you, Your Honor.
Well, still morning. Good morning.
Good morning.
What's your name?
Denmark.
Scottrell
Yes.
Denmark. Is that correct?
Yes.
All right, Mr. Denmark, in 2021 CF 286, you are charged with possession of methylenedioxamphetamine. Long way to say methamphetamine. Do you understand the charge?
Yes, sir.
All right, well, I do find probable cause for the charge. Now, you filled out an affidavit for us for the PD, but the clerk has indicated that you do not qualify for the PD. So I won't be appointing the public defender for you today. As far as an attorney is concerned, you're going to have to hire a private one, or at least attempt to hire a private one. And then if you're unable to do that, you can always let the court know what your efforts are to get a private attorney. And if you haven't been able to get one, we can reconsider the PD. Do you understand?
Yeah, I won't be able to get one.
I can't hear you, but it's probably
I said I
better.
won't be able to get one.
Your bond is $1,000, sir, and I'm going to put you down as to get on attorney. So you got to at least make the effort.
I will. I had seen PTR downstairs. They say I qualify as long as the court judge ordered it. I don't know if there's a possibility.
Are you asking me if I'm ordering PTR?
Can you, or is it?
I already have. I did. Or no, I didn't. I set your bond at $1,000. You got a fairly healthy history of failing to appear, and that's probably why you don't qualify.
They say I qualified downstairs, but
No, what I'm looking at says you don't. Did he?
They didn't qualify
Yeah, I
him.
didn't think so. So no, you don't qualify for PTR. Good luck. This, did I leave one in there? I probably did. Let's see, what's your name?
Crystal Mercedes Diaz Castellanos.
Okay, Ms. Castellano, you are in Division 12, 2020 CF 11496. That would be pursuant to a warrant, charged with possession of a controlled substance, providing false ID to a law enforcement officer, and possession of cannabis, misdemeanor amount. Now, the warrant found probable cause and set your bonds at $500 as to count 1, $150 each as to counts 2 and 3. And then you're out on bond on a burglary of a dwelling with an assault or battery, false imprisonment, battery, trespass. So, I'm going to leave those bonds or your conditions of release or the bonds in place as far as the out on bond. However, the new charges, the possession of a controlled substance, I'm going to increase that bond to $1,500. Your bond as to the false ID and the cannabis will be $500 each. So do you understand that?
Yes, Your Honor.
All right. Any questions you have, you want to direct them to the public defender because you do qualify for the PD, so I'm appointing them to represent you.
Okay, thank you.
Good luck. Was it in there?
No, I'm explaining.
I might have attached it to something else. I'm thinking. All right. Yes, sir. What's your name?
My name is John Emansky, Your Honor.
Emansky. Mr. Emansky, you are charged in case number 2021 CF277 with trafficking in morphine. That's more than 4, less than 14 grams. I did review the affidavit. I do find probable cause. Now, you also qualify for the services of the public defender. So would you like for me to appoint the public defender to represent you?
Well, I would, Your Honor, and I was
Okay.
talking to somebody last night for pretrial.
Yeah, well, I'm going to get to that.
Oh, okay. Yes, sir.
So I've appointed the PD for you.
Yes, sir.
You do qualify for pretrial release.
Yes, sir.
So I'll authorize your release, pretrial release. Now, pretrial release is going to be randomly testing you, so I'm ordering you not to consume any alcohol or drugs not prescribed for you by your own physician as a condition of your release, and PTR will be verifying that with tests. You
No problem,
understand?
Your Honor.
All right, good luck.
Thank you, sir.
You're welcome, sir. My poor daughter had to go take her grandma to the doctor today. And first of all, I guarantee you grandma didn't remember she had to go to the doctor. And she probably argued with her about doing it, and she was probably sitting there still in her pajamas when my daughter got there. And it's always interesting taking her to the doctor. I'm not sure what her doctor does other than just go, gosh, are you still alive?
Wow, wow.
Because I'm always shocked about that. Every time I go up there, it's like, I keep expecting to go there one day and knock on the door and nobody will answer. And then once I get in there, I'm gonna find her. And it's like, so whenever I go, well, I was gonna say I make my wife go in first, but she won't go in. I try to get her to go in, but she just won't do it. So, good afternoon now. What's your name, sir?
Ramon Feliciano, sir.
Feliciano. It's a famous name. In 2021 CF 285, you're charged with possession of cocaine. Do you understand that charge?
Yes, sir.
All right. Then I see you're out on bond on a possession of cocaine, possession of cannabis. I'm going to take no action on the case you're out on bond on.
Yes, sir.
As to the new cocaine charge, I'm going to kick the bond up a little bit.
Yes, sir.
To $2,500.
Yes, sir.
Now, you do qualify for the public defender, so if you wish, I will appoint the public defender to represent you.
Can I say something, sir? I understand.
Pardon me?
Can I say something?
No, you don't
Okay,
want to talk to me.
Okay.
You want to talk to your lawyer.
I'm sorry about that.
So you got the PD.
Yes, sir.
They're your best friends now.
We'll give you our number and you call us. We'll talk
Okay.
about it.
Thank you, sir. Have a great day.
You're welcome.
Appreciate it.
Good luck. All right, let's see. What's your name, sir?
Joseph Fleetwood.
All right, Mr. Fleetwood. I'm not gonna say anything. I'm totally quiet on this one. In 2020 CF 2918, you got some failures to appear. Looks like 1, 2, 3, 4, 5 counts of failing to appear for a status hearing on December 21st. And the court in Division 20 issued a capias and ordered you held no bond on that. Now, did he previously have the PD? All right. And so you're no bonded on the failures to appear, and I'll stay your status there. New charges are grand theft third degree, resisting, 2 counts resisting without violence, which is in case number 2021 CF 280. I'll find probable cause for those charges. Set your bond at 500 as to count 1, 100 each as to counts 2 and 3. And finally, according to your affidavit of insolvency, you do qualify for the public defender, so I'll appoint the public defender for you across the board on both cases. Understand?
Yes, sir.
Any questions? Direct
No.
them to your lawyer. Good luck.
Thank you.
What time y'all get out of here today? 3. It does get kind of lonely back there every day after 1 o'clock, doesn't it?
Oh, we don't know.
When everybody books? Oh, you don't care? Okay. I'm good with that. I could just hang around all day and entertain you. You don't want that. You wouldn't get anything done. You'd be coming in Monday with all this stuff to do.
I'll just leave it for the sake of it.
Yeah.
Yeah.
All right. So, what's your name?
Desmond Good.
All right, Mr. Good. Let's see what we got here. In 2021 CF 283, you're charged with possession of cannabis with intent to sell or deliver with a weapon, and possession of cannabis more than 20 grams with a weapon. I did read the affidavit. I find probable cause for some of it, not all of it, and you do qualify for the public defender, sir. Do you understand?
Yes, sir.
Okay. What I'm finding probable cause for is possession of cannabis with a weapon. I'm not finding PC on the intent to sell. And possession of cannabis, well, I mean, that really kind of consolidates the two charges into one. But while there are two pending, and this case is in Division 10, by the way, you qualify for pretrial release. And so I'm going to authorize your release, pretrial release. And that's no PC on the intent.
So,
and
which
order that you consume no alcohol or drugs that are not prescribed for you by your own physician as a condition of release. And I'm going to have PTR randomly test you to make sure you're complying with that court order. Understand?
Could you?
All right, good luck.
Okay.
Thank you.
Is it a different statute number?
No, same one, I think.
So, Your Honor, it's only going to be one charge?
No, there are
gonna be
two,
both.
and so he's PTR'd on both. So, PTR'd on one, PTR'd on 100, it's all the same thing. I'm just not finding PC for the intent, which kind of makes the two charges exactly the same.
So Judge, can we do no PC, ROR count 1, and then PTR on count 2?
Yeah, we can do that. So no PC, but it's only on the intent part.
I understand.
But again, they do collapse into sort of one charge. So that makes sense.
Thank you, Your Honor.
So no PC, ROR on count 1, PTR on count 2.
Okay.
Okay, let's see. Next up there. What's your name?
Leo Heflin.
Mr. Hallback, you are charged with...
Hallback refused court, Your Honor. Stephen?
Hallback did? Okay.
Hallback bonded, Your Honor. Excuse me. Hallback bonded.
Oh, he did? Okay. So that's why I guess his affidavit is blank. Well, it's the inability to hear. And so, tell me your name one more time.
Herbison.
Herbison.
He refused court, Your Honor. Stephen.
Did he? Yeah, he's already got the PD on the one he's out on bond on?
No, you filled one out.
Oh, he did? Hey, despite the fact that he refused court, he did fill out an affidavit. He qualifies for the public defender. I can see why he refused court. His new charges are possession of heroin, possession of methamphetamine, possession of drug paraphernalia. That's in 2021 CF 293. The bonds are $1,000 as to count 1, 150 as to count 2, 100 as to count 3. Now he's out on bond on the same thing twice. Once in July and again in October. Same basic set of charges. I'm going to revoke all his bonds on both those cases or his conditions of release. Order that he be held no bond on the ones he's out on bond on. That's Division 15 on the first one. Don't know what the division is on. Oh, the other one's Osceola. Forget the second one. That's an Osceola case. 2020 CF 3197. No action on that. Revoke his bond on 20 CF 8498 and direct that he be held no bond on that. It looks like he probably has the public defender appointed on those already. And I'm appointing the PD for him on the new charges.
Your Honor, I'm sorry, are we talking about Hallback or Harbison?
Harbison.
Okay, and you revoked the 2020 3197?
Both out of bond cases.
No, I didn't revoke 3197, that's Osceola,
Okay.
but I revoked 8498. Did I? Yeah, I just did. Let's see. Yeah, he's got a grand theft third degree of a motor vehicle. That's in 2021 CF 290. That's a new charge too. Bond is $1,500. I'll find probable cause. Stay as bond at $1,500. And that should do that. So, and what's your name?
Neil Heflin.
All right, Mr. Heflin. In 2021 CF 245, you're charged with burglary of a dwelling and criminal mischief. And then you got a no motor vehicle registration in 21 CT 223. And you're out on bond on some stuff on ROR, which I've been handed an order to revoke your release status on the on case 2020 CF 10847. Let's see, what do we got? Battery by strangulation? Yeah. So I'm revoking that bond, or revoking PTR, based on the nature of the charges. I'm going to order you held no bond pending further order of the court in Division 17. As to the burglary of a dwelling, I'll stay your bond at $5,000, $150 as to the criminal mischief. You're ordered not to return to the scene of the offense, no contact with any victims or witnesses. As conditions of release, no weapons on or about your person. As to the no motor vehicle registration, I'll set the bond at $100. And you do qualify for the public defender, sir, so I'll appoint the public defender to represent you.
Yes, sir.
Thank you. Good afternoon. Your name?
Tyson Herzig.
All right, Mr. Herzig, you are charged with possession of cocaine, which is a F3, and also abuse, misuse of a temporary tag to avoid vehicle registration. It's a temporary tag charge, but charged that way, I guess that rises to the level of a felony? I don't know. At any rate, having reviewed the affidavits, I do find probable cause. You qualify for pretrial release, so I'm going to authorize your release, pretrial release.
Okay.
Now, PTR will be monitoring you and testing you randomly.
Okay.
So I'm ordering you to consume no alcohol, no drugs,
Okay.
except drugs prescribed for you by your own physician.
Sure.
As a condition of release. And
Okay.
it's PTR on that crazy registration charge too. So PTR in both cases. Good luck, sir.
Okay, thank you,
and
sir, I appreciate you.
You do qualify for the PD, appointed
Public
PD.
defender? Okay.
Just the cocaine case.
Thank you.
Let's see, good afternoon, what's your name?
Donnie Johnson.
All right, Mr. Johnson, you're charged in 21 CF 301 with trafficking in methamphetamines. That's more than 28 grams in possession of methamphetamine with intent to sell or deliver. I did review the charging affidavit. I do find probable cause. You also qualify for the services of the public defender. Do you want me to appoint the public defender to represent you? Yes?
Yes, sir.
Okay. The bond on the trafficking charge is currently set at $100,000, 15 on the methamphetamine with intent, which I would reduce to $150 on count 2. Your bond remains at $100,000 on count 1, and if I didn't say it, you do qualify for the public defender. Understand?
Sure.
All right, well, good luck. Lemons. Good afternoon, sir. Your name?
Charles out of Lamons.
All right, Mr. Lemons, you are charged in 2021 CF 292 with driving while your license was revoked as a habitual offender, fleeing and eluding, and resisting without violence. Do you understand those charges?
Yes, sir.
All right, now, according to your affidavit of insolvency, you do qualify for the public defender. So bond on the driving while revoked as a habitual offender is $2,500. On the fleeing and eluding, I'll set your bond at $150. On the resisting, at $100. Now, you're ordered not to drive without a valid driver's license as a condition of your release.
Yes, sir.
So, any questions you have, you want to direct those to your attorney, sir. Good luck.
Sir.
You know that things change, and yet they stay the same. For as long as I can remember, law enforcement rounds up all the felons at the end of the week. They do.
Yeah.
And they do the same thing out in juvenile. They go out and pick up juveniles with writs and warrants, pick them up on like Friday.
Oh, wow.
Which, I mean, I'm sure there's a logic to that for them, but I'd just assume they spread it out over the week a little bit.
It's perfect. I pick 'em up.
So your name?
Miguel Angel Morrow.
Mr. Marrero, in 2021 CF 263, you're charged with aggravated assault with a firearm, possession of a firearm by a convicted felon, discharging a firearm in public, and possession of methamphetamine. Do you understand those charges?
Yes, sir.
All right, sir, I reviewed the affidavit. I do find probable cause, and according to your affidavit, you do qualify for the public defender. Would you like for me to appoint the public defender to represent you, sir?
Yes, sir.
All right, I'll do that. And your bond on the aggravated assault with a firearm, let's set that at $2,000. You have a $4,000 bond on the possession of a firearm or ammunition by a convicted felon. Discharging a firearm in public will make that $150. Possession methamphetamine $150. Understand?
Question?
What?
Question?
Well, you may want to ask your attorney the question.
Okay. Sorry about that. So it went lower. It went lower. It went lower. Okay, and it's 4,000 is 10%.
In addition to the bond, sir, you're going to be ordered to have no weapons on or about your person. And you're also going to be ordered to turn in any weapons that you own or regularly have access to.
Yes, sir.
To the Orange County Sheriff's Department within 24 hours you're released from custody.
Sir.
All right? Good luck. Thank you. All right, you're... Oops.
What's the defendant's name?
Let's see. Your name, please.
It's Luis Negron.
All right, Mr. Negron. In 2021-244 CF, you're charged with possession of heroin, possession of methamphetamine, providing false ID to a law enforcement officer, and possession of drug paraphernalia. Do you understand those charges?
Yeah. Yeah.
Okay. According to your affidavit of insolvency, you do qualify for the public defender. Do you want to have the public defender appointed to represent you?
Yeah.
All right, I'll do that. And your bond on the new charges, $1,000 on the heroin charge, $150 on the methamphetamine charge, $100 on the false ID charge, $100 on the drug paraphernalia charge. Understand all that? All right, and if you have any questions you want to ask your attorney, sir. Good luck. I guess it's kind of a shock when the private attorneys come in and we're doing all this stuff early. That's probably the biggest danger involved in it. So, yeah, we'll figure out something. Good afternoon. What's your name, sir?
Leo Nieves.
All right, Mr. Nieves, you are charged in 21 CF 302 with possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, tampering with physical evidence, and resisting without violence. Now, all of that is pursuant to a warrant, and the judge signing the warrant found probable cause for the charges and set your bonds at $5,000 as to count 1, $2,500 as to count 2, $1,000 as to count 3, $500 as to count 4. I'm going to add to those bonds that you are ordered to have no weapons on or about your person as a condition of release. Any weapons you own or regularly have access to, you are to turn over to the Orange County Sheriff's Department within 24 hours of your release. And if I didn't say it, you do qualify for the public defender. Good luck.
Can I pass by Mr. Pacheco, Your Honor?
What?
Pass by Mr. Pacheco? He has private attorney.
Is that who the gang that just came in was for?
Yes.
Let me just look and see here. Oh, yeah, okay. That ain't gonna happen. Well, I guess it could. All right, good afternoon.
Mr. Parker bonded.
Parker Bondage. And your name?
Brian Perez Cave.
All right, sir, you are...
Hands down. Just take a peek. Take a peek. Put it down.
Let's see what we got here. You're charged with possession of heroin, possession of drug paraphernalia, and possession of a misdemeanor amount of cannabis. You understand those charges?
Yes, sir.
All right, well, having reviewed the charging affidavit, I do find probable cause I notice you're out on bond on a possession cocaine, possession paraphernalia. What I'm gonna do is revoke your ROR status on that and set a new bond on the cocaine charge at $1,100 on the paraphernalia. And then your bonds as far as the new charges, which are in 2021 CF 278, $1,000 on the heroin charge, $100 each on the paraphernalia and cannabis charge. And you do qualify for the public defender, sir. So do you want me to appoint the PD for you? Yes?
Sir. Yes, sir.
All right, I'll do that. Good luck. And your name?
Yabani Pocasangre, sir.
How about Yabani De Jesus Poca Sangre?
Yes, sir. Sorry.
That you?
Yes, sir.
Yeah, I didn't hear you.
He said it very quickly, Your Honor.
What?
He said it very quickly.
Okay, let's see, in Division 17, 2021 CF 289, you are charged with grand theft of a motor vehicle. Do you understand that charge?
Yes, sir.
Huh. I don't really see why, but you don't qualify for PTR. So, I'm gonna set your bond at $500. And, I've appointed the PD for you, so if you have any questions, you wanna talk to your lawyer, okay?
Yes, sir. I already.
Understand?
Yes, sir.
I'm not your lawyer.
Yes. I already did the bond, so would that still go through?
What?
I already paid for the bond. Will that still go through?
I heard, I've already paid.
I've already
the
paid
bond.
for the bond, so will that still go through?
It hasn't posted yet, Your Honor. His bond hasn't posted.
Ah, I see. Well, that's something you'll have, you got a bondsman posting the bond, right?
Yes, sir.
Okay,
Yes.
you'll have to go over that with your bondsman.
Okay. So what?
Good luck.
What happened? What?
I didn't mean to mess him up.
Can I pull my last name?
All right, your name, please.
David Ramsey.
David Ramsey?
Yes.
All right. Mr. Ramsey, you are charged with, well, it's a violation of a condition of pretrial release in Division 11, 2020 CF 10990. The conditions that you're alleged to have violated is you're supposed to have no contact with the victim, and apparently somebody believes you did. The court in Division 11 issued a warrant for your arrest on the violation and has ordered you held no bond. Now, did he have an attorney in the case?
Yes.
Public defender? Okay. So the PD's previously been appointed to represent you, and I'm sure they'll be setting you up a bond hearing with the court in Division 11. Understand?
All right.
All right, good luck, sir. All right, your name, please.
Bailey Reuter McDonald.
All right, Reuter McDonald. Ms. Reuter McDonald, you are charged dealing in stolen property, receiving money from a pawnbroker by false verification, 2 counts of that, another count of dealing in stolen property. It's all pursuant to a warrant. in case number 2021 CF 216. Court that reviewed the warrant found probable cause for each of the 4 counts. Set your bonds at $1,500 on each count. Now, your affidavit indicates that you do qualify for the public defender. Would you like for me to appoint the public defender to represent you?
Yes, sir.
I will do that at this time. Any questions that you have, direct them to your attorney.
Thank you.
Good luck.
Your Honor, can we satisfy Mr. Reynolds?
Sure. Just put him up here in the, we're passing by pot. And your name, sir?
Justin Riley?
All right, Mr. Riley, oh, you got some failures to appear, looks like in drug court, in 2018 CF 5926. Says you failed to appear for a status hearing on October 30th
Yes,
of
sir.
last year. Well, the judge in drug court issued a capias and ordered jail no bond on that. And, huh? Another, a private attorney?
No, he doesn't have that at all.
Oh, he doesn't? Okay. You want me to appoint the public defender for you on that? You qualify.
Yes, sir.
Okay, I'll appoint the PD for you. And, yeah, you're gonna have to appear in drug court to get a bond, I guess. So, good luck with that.
Does it have a date?
We don't have a date right now. We don't get dates for that. Your attorney, if need be, no doubt drug court will set a hearing, probably at the request of your attorney, or they may have their own system set up to monitor what comes through here. But as of right now, we don't have a date. Good luck. And your name, please.
Peter Ciacia.
How about Jose Santiago?
He's medical, Your Honor.
Medical? So, is that something you want to reset, counsel?
No, we'll waive, Your Honor.
Okay. Well, he's got a new charge in 2021 CF 274. That's possession of methamphetamine. Then he's got a failure to appear in Division 82 for a status hearing, and that got a bond of $500. The methamphetamine charge bond is $1,000, and I'll go ahead and appoint the public defender to represent him. So, that works for me. And next up is Mr. Scasias. I didn't say that right. How do you pronounce that?
Ciacia, Your Honor.
Oh, it was close. All right, you're being held in 2021 CF 288 on charges of possession of cocaine and possession of drug paraphernalia. Do you understand those charges?
Yes, Your Honor.
Well, having read the affidavit, I do find probable cause for the charges. Bond is $1,000 on the cocaine charge, $100 on the drug paraphernalia, and you do qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes, Your Honor.
All right, I'll do that. So, good luck.
Thank you.
Your Honor, I have a probable cause challenge for the next client.
Well, somebody said something to me, but I didn't hear.
I mean, I have a probable cause challenge for Mr. Stevens.
All right. So, let's see here. That's 2021 CF 249. Charges stacked up: armed burglary of a structure with a firearm, criminal mischief, possession of firearm in commission of a felony, carrying a concealed firearm. I think I know what your PC argument is. I don't mean to steal your thunder.
No, you know what? If I won't make it, if you're not gonna, I
Well,
won't make it.
we may disagree as to this, to the degree, but if I read this affidavit correctly, the weapon was in a vehicle. He was out of the vehicle, according to this, beating up a building with a stick or something like that. And he got charged with burglary of a structure. I suspect that was for jumping the fence. And then criminal mischief, banging on the wall, breaking a window, possession of a firearm in commission of a felony, and carrying a concealed firearm. So, my PC issue with this was that his armed burglary of a structure should be just a straight up burglary.
He was found in the vehicle, Your Honor.
Yeah, I know, he was in the vehicle, the firearm was in there, but there's no indication that he had the weapon with him when he was banging on the building. And then criminal mischief, PC, possession of a firearm in the commission of a felony. I mean, at that point, basically, he's resisting, which is a misdemeanor, and he's in a vehicle. So I would have a PC issue with that one. And then carrying a concealed firearm, it's in the vehicle, he's in the vehicle, so there appears to be PC for that.
Well, the way I read it is, so he's outside busting up the structure.
Right.
And then they have a helicopter overhead, and it seems to chase him, so he runs off, and then he hides out in a car to escape them. I don't believe it was his car. I believe it was someone else's car.
Well, the affidavit really doesn't establish that it's his vehicle, just that he was in the vehicle with a weapon.
So, yeah, so my argument is going to be that there's nothing to suggest that that firearm even belongs to my client. It could have belonged to the person whose car it was. So the carrying a concealed firearm or the possession of a firearm, there should be no PC for those two charges either.
So state's gonna request that he be held at no bond for 24 hours for state to get additional information for probable cause.
All right. I think I'm obligated to give the state those 24 hours, the request with the PC problem. So, you know, presently, he has no bond on the armed burglary of a structure. I'll leave that at no bond. His other bonds, I'll stay for the present. And then, so tomorrow, y'all will spring that on the duty judge.
Yes,
Well,
we will,
That
Your
ought
Honor.
to be fun.
One quick thing before we finish. Now, I'm not arguing that the state is entitled to their 24 hours.
Right.
But I didn't read anything in the statute that said that my client had to be held at no bond for those 24 hours. It may be in the court's discretion to offer a bond in the interim, Your Honor.
But the court can't find anything dealing with probable cause, period, one way or the other. So he is to remain at his current status, giving the state 24 hours to provide additional documentation for the court to make that probable cause determination.
I think state law as well as local rules contemplate that when the state makes a reasonable request for an additional 24 hours on a PC issue, that they're entitled to it. And then in the interim, and again, because it's such a short period of time, that in the interim, everything is stayed as is. So
Okay.
I understand your argument, I appreciate it, but I believe the state is accurate on that.
Okay.
As much as it hurts me to agree with the state. And it's very painful. So we'll do that, and it'll come up tomorrow for, either one of y'all working this weekend? Okay, tell them it was Judge Let's think of a name real quick. Tell me it was Judge Thompson. Emerson Thompson ordered this. And see if you get any flack from him, okay? And, you know.
Judge Murphy is the judge.
Who is it?
Mike Murphy.
Mike Murphy? Well, Murphy's, you know, like everybody's genius, so
He is.
whatever problems you have tomorrow get resolved by the young genius judge.
Is he the young genius judge anymore? I think he's been on the bench long enough to not be the young.
I know you love Judge Murphy, and everything I say negative about him is you're going to argue with me about it.
I just said he's not the young one anymore. That's.
I like Murphy too. He looked young the last time I saw him, but you know what? These days, virtually everybody looks young. I'm seeing, you know, judges back there that are just barely older than my youngest, who's like 22. So, yeah, I feel old. You make me feel old. It's all your fault. So, you understand what we're talking about here, sir?
So basically, I would have.
You're here on no bond. You're gonna be here for a little while. Tomorrow, this case is gonna be called again because the state wants to see if there's some supplement to the existing charging affidavit to determine if probable cause can be established on a couple of these charges. I have an issue with a couple of them. Your attorney has an issue with a couple of them. That gives everybody a chance to be heard on that issue if the state can supplement the record. That makes sense?
Yes, sir.
Okay, well, good luck.
Thank you.
Have a good evening.
Yes, sir.
Stay on?
No, I know the thing, but we'll call.
No. It's only PC on count 1, the armed burglary,
Okay.
and then totally on count 3.
Okay.
So,
Thank you.
that make sense?
Yeah.
Okay. You need a minute?
No.
Let's see. Good afternoon, sir. What's your name?
Brian Crawford.
Who?
Brian Crawford.
I got a Jaden Stevens. But that was just him, wasn't it? Okay, well, all that talking got me confused. It was the dementia
All right,
thing.
let's make it. I'm on in a fun argument moment.
Brian Crawford.
Yes, sir.
Okay, Mr. Crawford. You're here on a violation of probation.
Let's have fun today.
Sounds good.
And that's in 2013 CF 17129. Violations alleged are that you failed to report to probation on August 15, 2019, that you failed to report for the same date, that's the second violation, changed your residence without consent, July 2019, current whereabouts unknown, refused to submit to random testing as a condition of your probation. And this probably won't come as a shock to you. The court signing the violation has ordered you held no bond.
Yes,
All right?
Yes, sir.
Now, picked up a couple others. Possession of a controlled substance and possession of drug paraphernalia. That's a capious and a probable cause order that was issued, setting bonds at $1,500 is to count 1, $500 is to count 2. You're also ordered not to possess or consume any alcohol, illegal drugs, controlled substances without a valid prescription. Understand?
Yes, sir.
Okay. Now, you filed an affidavit that indicates you qualify for the public defender. Would you like for me to appoint the public defender for you, sir?
Please, sir.
All right, I'll do that. And any questions that you have, you're going to direct to your lawyer. Good luck.
Thank you, sir.
You're welcome, sir. Good afternoon. What's your name?
Christina Register, Your Honor.
Aha. Okay, this looks like a violation of probation.
Yes, Your Honor.
You probably already knew that.
Yes.
Violation in 2018 CF 13430. And the violations alleged are moved from your last place of residence in Gulf Breeze without the consent of your probation officer, left the county of your residence without the consent of your probation officer, and failed to undergo drug and alcohol evaluations. You know, the judge has signed a warrant, has ordered you held no bond on that. And looks like you qualify for the public defender. Would you like for me to appoint the public defender for you?
Well, Neil McShane has been advising me. I haven't talked to him. I turned
Neil
my...
McShane?
Yes, sir.
Is he still alive?
Absolutely.
Have you checked recently?
Yeah, I talked to him.
Watch the obituaries to make sure he's still there?
He told me to complete everything here, my evaluation, all my classes, so that's been done. I actually brought copies with me when I turned myself in yesterday.
Yeah.
All I have left is my 20 hours of community service. My probation officer said I could be back on probation.
Well,
but I don't know.
The court that signed a warrant that reviewed the affidavit
Okay.
has entered an order, and the order
Okay.
is that you be held no bond pending further order of that court. I'm going to suspect that next week sometime you're going to be down there in courtroom 3,
Okay.
and hopefully Mr. McShane will be there.
Okay.
You ever notice how he bounces around like a little bunny?
He's not even in town right now. Yes, I do.
Yeah, he does a lot of bouncing.
Okay.
But I've known Neil for a million years.
Okay.
So he's a good guy.
Yeah.
You know he's a Vietnam veteran?
He told me, a captain, yeah.
Tells everybody.
I know. We were on the phone for 2 hours, my first call, yeah.
Yeah, but he's a good guy.
Yeah, definitely.
He's a good guy.
Yeah.
So what he's going to do, I'm sure he or somebody from his office is going to work on, you know, a release for you.
Okay, got it.
But in the interim, you're kind of stuck.
I'm stuck here, okay.
I don't even know why they have us do these things.
Yeah, I don't.
Because every time I've ever fooled with one of these VOP affidavits and
Yeah.
gave somebody a bond,
Yeah.
they get upset downtown.
Okay.
Which, you know,
Yeah, I
but
understand.
so you'll be talking to Neil about that. You just be a
Okay.
guest for a while.
Okay, so like a week you said, maybe?
Maybe a week, maybe less.
Okay,
Good
thank
luck.
you.
Thank you. McShane. You guys like McShane, right? No? You don't care for him? I'll tell him next time I see him. Let's see. What's your name, sir?
Jason Raphael White.
Mr. White. Well, what do we got? You're out on bond on a burglary of a conveyance, grand theft, 3rd degree. And now your probation's been violated, probably because of those new charges.
No.
Well, maybe not. It might be something else. Let's see what it is.
Community service.
Failing to successfully complete 150 hours of community service. So you've been no bonded on that, on the affidavit violation. And this is the kind of case where typically I would consider a bond, but you are classified as a violent felony offender of special concern.
Can I
Florida
say
law
something?
very clearly says that without the direct consent of the judge where the case is pending,
Right.
that the first appearance judge is not allowed to mess with that at all. You
Right.
got to stay on no bond pending further order of that court.
Right. Can I say one thing?
No, not yet.
Okay.
And you do qualify for the public defender, so I've appointed the PD for you. So why don't you make your comments to the attorney rather than blowing it by talking to me? Yeah, no action on that. I'm not taking any action on the out on bond. He's got one no bond. How many no bonds does he need? All right, your name, please?
Evan Altman.
Altman. Yeah, it's a, looks like a violation of probation. In 2020-215-269, that's a good size number. That's 215,269.
Your Honor, I'm thinking this is Evan Altman.
Yes,
He's an out-of-county warrant with Volusia County.
he is an out-of-county one. You are absolutely correct. It's Volusia County too. And Volusia County wants you held no bond on the out-of-county warrant. Do you understand that?
Yes, sir.
Well, you know what I can do, and I will do, appoint the public defender for you locally here. That's for purposes of whatever might need to be done here, not in Volusia County. And what's going to happen is, although we got word yesterday, I say we, one of the J's back there was telling me that they got word that everybody in the state was going to be transporting again. So if that's the case, is that what y'all hear in corrections?
Yes, Your Honor.
Okay, that's why I ROR'd that one lady this morning that hadn't been transported, right? DeSoto County? Where the heck is that? Isn't that Arcadia? I think it is Arcadia. So at any rate, what we're gonna do is, I think, this is what we were doing, contact Volusia County to see if they're gonna transport you. And if they're not, and they don't do something within a reasonable period of time, we'll bring you back and talk about what we're gonna do with you, okay? Worst case scenario, you get shot at dawn. Okay?
Yes, sir.
No, we're not gonna shoot. So good luck.
Thank you.
I had a case out in Ocoee once, years ago, and it was a Spanish-speaking lady. She was there with her husband. He was translating for it. I mean, translating, interpreting. Translator is Star Trek. So he was interpreting. And I don't know what she was charged with, petty theft at Disney or something. We used to see a lot of those cases out at Ocoee. They had this big stack of Disney theft cases that you had to go through every day. And you know what was really surprising about that is about 90% of them were people from Brazil. So there was this standing joke out there. Well, I won't say it because if I do, I'm sure I'll be on Channel 9 tonight. So rather than be on Channel 9, I'll just tell you after we go off the record. But at any rate, so I'm saying, you know, you charge with whatever it is and blah, blah, blah. And he's doing this great job of interpreting. And when I asked her how she wished to plead through her husband, she asked me, well, what was I going to do if she pled guilty? And, you know, I wasn't really thinking when I said it, but it's a long morning. And I said, well, we're going to have you shot. Now, typically the interpreters would know not to say that because it's me. And he said it quicker than I could stop him. I thought this lady was going to have a stroke. I mean, she went totally pale and grabbed her heart, you know, and I'm coming, Elizabeth. And I said, no, we're not going to shoot you. And what really bothered me about it was her husband didn't seem to be bothered by the fact that I was telling her we were going to shoot her. And I thought, okay, well, I'll not get involved in that anymore. So, did I learn something? No. That ought to be pretty obvious. So, let's see. What's your name?
Vaughn Cook.
Mr. Cook. What do we got? Out of county warrant, out of, let me see here, Marion County. And it's a felony VOP. Probably not shocking that Marion County has ordered you held no bond. So, again, I'm going to appoint the PD for you locally. And then we'll contact Marion to see if they're going to transport. If not, we'll bring you back to court and talk about it, okay?
All right, yes, sir. Thank you.
You're welcome. Good luck, sir. This is, who is this?
Good afternoon, Your Honor. It's William Pinnell and Elizabeth Fryer for Louis Pacheco.
Okay, I got it. And, let me see, that's a warrant. The case number's 2021 CF 2120. Charge is sex battery on the physically helpless. Y'all are gonna be stepping in for all purposes in this one?
For limited purposes of today, Your Honor.
Okay, so, he qualifies for the public defender, so being as how counsel at this point is limited to today, I'll appoint the public defender for after this hearing, okay? So with that, he's presently being held no bond, so go right ahead, counsel.
Judge, we have a probable cause challenge, which is pretty important in this case, and if I may approach with some case law.
All right.
Your Honor, my only response to that would be that because this is a warrant case, that probable cause has already been found.
Yeah, that is
That
a
is
bit
the
of an
problem.
issue. You got a warrant that a judge reviewed and determined that probable cause existed, which sort of limits my involvement in it to just simply saying, here's your status, and either granting a bond or not granting a bond.
Okay, well, certainly this issue would also be relevant to whether, first of all, I don't think the court should, I think the affidavit's pretty clear that there's not probable cause, and I understand you don't want to substitute your judgment for the other judge.
Right.
But you have affirmative statements, sworn statements from the victim in this case, the alleged victim in this case, that we believe, under the case law, established that she was not physically helpless. So if the judge, we think, first of all, that you should correct the mistake, but if we're not inclined to do so, we would argue that it's relevant to whether the state could show proof evident presumption great on this charge. It's important in this case because as charged, it's an F1 PBL. If it's reduced without the physically helpless, it's an F1 and he's entitled to bond as a matter of right. So whether the court disturbs the probable cause finding or not, we think based on the affidavit where the alleged victim is clearly able to express her lack of consent, and that this is on page 2 of the affidavit. Let's see.
And Judge, prior to the court making that determination, I think we need to be very clear on the record that if the defense is going to go forward with the author hearing, as of right now, then that is their one bite at the apple. I know defense counsel hasn't been here recently on how we're handling IAs. However, that if that is, they're waiving that the defendant's right to have another author hearing downtown. So if this court finds proof evident presumption great, and he continues to be held at no bond, then that will not, then I will make sure that note is done for my colleague downtown to not have another bond hearing because we've had it at the jail. And so I understand that defense counsel has not recently been here, so that's why I want to make sure before we start making those arguments that we're very clear on what is happening procedurally, not even about the basis of the facts of the case.
Are you talking about an affidavit separate from the affidavit attached to the warrant?
I have.
No, I printed a copy of the affidavit for the
I have an
warrant.
affidavit for arrest warrant that I'm looking at, 3 pages.
And where'd you say that was in there? Because I read it, I don't recall seeing that.
On page 2, let's see, the paragraph that said, Lewis then kneeled or stood up on the back seat. And then it said, and placed his D in the victim's mouth. He then stopped, told her to let it happen. The victim, quote, stated to them, "This is rape, I'm 14. And then later it says the victim then texts her 16-year-old female friend they're trying to rape. So under the case law, physically helpless under 794-011E means unconscious, asleep, or for any other reason physically unable to communicate unwillingness to act. She, in this case, stated her unwillingness to act. She said, I'm 14, this is rape, voiced her objection to what they were doing. So it doesn't meet the standard of physically helpless.
So the argument really is as to whether she was helpless or not. Really, it's not as to whether there was a sex battery, because the moment he stuck his business in her mouth, the act was done. That's
Correct.
the deed.
Correct.
And so as far as the sex battery is concerned, there's no question about that. It's about whether she was physically helpless or not.
Correct, Your Honor.
Okay.
And that's...
So that's where we're at.
Correct, and that So it's our argument that there's not proof evident presumption great of the physically helpless. And as the court knows, and I'm happy to provide case law, proof evident presumption great is a standard greater than beyond a reasonable doubt. So here, when we have the victim telling the officer that she verbally expressed her unwillingness to act, it's our contention that the victim herself has eliminated that element, and there's no way the court could find that element has been proven by proof evident presumption great. The third DCA in a similar case said where, in Bullington, said where the victim was tied up but was able to verbally communicate orally that she did not want to engage in sex acts, that it was not physically helpless. And in Norman from the 5th DCA, the court says where the victim of sexual battery was able to communicate her unwillingness and did so before and during commission of offense, the defendant could not be convicted of committing sexual battery when the victim was physically helpless to resist. So it's our contention that there's probable cause and arguably the state could prove proof evident on the lower offense, which is an F1, but cannot meet that burden on the subsection 4A, physically helpless, and that the defendant is entitled to a bond as a matter of right.
So, Your Honor, even if state was to agree with defense as to that paragraph, right? And that's not saying state is, but let's say for argument's sake.
All right.
If we go to a paragraph before, Lewis put her head on his lap. One of the males say, let's check here. Andy placed his hand inside her bra. Then his hand moved inside her pants. And at that point, Lewis was present, just based on what we're reading the paragraph ahead. And if I go 2 paragraphs ahead, she is says that she was intoxicated, could not speak. So at that point, Lewis and the co-defendant at this point are sexually battering her. From at that point in the affidavit, all we know is that she said she was intoxicated and could not speak. This is prior to her saying, once he put his D in her mouth, that she then said, this is rape and I'm 14. So we have 2 different acts. We have the act where the defendant puts her mouth in his private area, and we have another act in the previous paragraph where he is with the co-defendant, where the co-defendant is putting his hands underneath her shirt and inside her pants. So we have 2 different sexual battery acts where the defendant is participant in it and helping to complete the acts.
Well,
So
I don't disagree with anything either one of you have said. Clearly there's a sex battery based on these facts. The question is, was she helpless? But then we come back to the dilemma of the judge who signed this warrant. I'm not going to look to see who signed it, but whoever signed it found PC on both.
Okay.
So they exist at this point.
So again, we're willing to move forward with the Arthur hearing today. So we're not asking, if the court's not willing to disturb the probable cause finding, but we're asking the court to find that there's not proof evident presumption great for physically helpless. So again, and I think it's important that the state is arguing an act committed by the co-defendant. Our client's not charged with that. He's charged with the...
Your client did enough. So, all argument in the world is not going to brush away these charges from him.
I'm not asking you to brush away the charges.
Are you really after a bond today?
I am, Your
I
Honor.
mean, that's really what this is all about.
Yes.
Let's get him a bond, get
Yes.
him out of jail.
Yes.
How old is he?
He's 18. He's been 18 for 11 months.
This is where flogging, when they took it out of the law, yeah, bad idea, but nonetheless, that's what we got. So what they're really looking for is a bond. What are your thoughts on that, State?
they believe the defendant should continue to be held at no bond based on the charge itself is a punishable by life offense.
It is a punishable by life. What are his connections to the community? I mean, he lives here, he goes to school here, says he's in high school.
He has no priors when I look at the face sheet, Your Honor.
Yeah.
And Your Honor, Elizabeth Fryer for Mr. Pacheco.
I can't hear you.
Sorry, it's the mask, Your Honor. Sorry about that.
Oh, it's been going that way all week.
Just yell. That's what we all do here. Just yell.
Just enunciate. So Mr. Pacheco has about a half a dozen family members downstairs, including his mother, his grandfather, his stepfather, aunt, uncle, and a mentor of his. His ties to the community are he currently lives with his grandfather and works for him. He's graduated high school. His family is incredibly supportive of him. He'll be able to continue, I'm proffering it out, he'll be able to continue working with his grandfather when he leaves here today. His grandfather owns a construction company. He'll be able to continue to live at the home as well.
Is he a senior in high school?
He's graduated since, but he has Valencia credits and by all
Okay,
accounts.
so he's graduated from high school.
He's graduated high school, he has Valencia credits, and by all accounts, he's got excellent grades. I do, for what it's worth, I do want to point out that as soon as this young woman verbalized, based on her statement, Mr. Pacheco stopped. As soon as, based on the affidavit, you'll find the second to the last line there, as soon as she verbalized that this was not something that she was interested in, Mr. Pacheco, based on her statement, stopped. So whatever led to this, however we got here today, this isn't a case where once an individual said, you know, this isn't something that I'm interested in, he continued on. He took heed based on law enforcement's stance there, and that is in absolute alignment with every other area of his life. His family support, his record, which is nil, and his work history. So we're asking
So
for
you
more.
say at present he's working with his grandfather?
Correct. His grandfather is
Okay.
present as well. He's downstairs.
Yeah, and no offense to you for the argument.
None taken.
You gotta do what you gotta do. But, see, I'm not impressed, because up to that point, she's still only, 13, 14?
She is.
So the fact that this occurred, and she's 13, 14, all the combined facts, he gets nothing in the way of any points for his behavior, as does his co-defendant. And I don't mean to imply that he does.
No, I understand
But,
that.
reading the facts, and there's nothing in the warrant indicating that the court who signed the warrant was objecting to this court reviewing conditions of release and potentially setting a bond. Based on all of that, as long as we can arrive at some conclusions about where he's going to go or where he's not going to go as a result of this, and because I ran into the same problem when I read the affidavit, and that being that had I read it initially, I would have had some questions for the officer presenting it about this, the helpless part of it. She appears to be conscious and aware of what's going on, but she still can't consent to anything, not at that age. Sex battery is sex battery. I don't have a problem with setting a bond. I'm inclined to set his bond at $25,000, order that there to be no contact with the victim, that he has to have no unsupervised contact with any person under the age of 16 as a condition of his release. I'm also going to order that he be home. He works, he's got Valencia credits. If he's at Valencia, he's virtual right now, so he can do that through there. But he's going to be confined to home. Now, we don't have the home confinement things that we had once upon a time in this county. So what I'm going to do is make PTR a condition of his release. PTR will be randomly checking to make sure that he is staying at home. He is not to leave the house until further order of the court.
I'm sorry, Your Honor, but that charge, we could not place him on pretrial release.
I think it's the admin order. Will not let those.
Yeah, any sex crimes, we can't monitor under pretrial release.
So, how do we keep him at home?
So if this were federal court, then we'd have a third-party custodian that would speak up on his behalf and act in that role. We have several family members, any one of which, and I assume that would likely be his grandfather, since he will be living and working with him, that could take that role. So you'd be ordered that if he were to violate that in any way, Grandpa would have an order to do that. You'd have to accept that, and if there was any violation of that, he would be considered in court.
Then I'll rely upon you as an officer of the court
Yes, Your Honor.
to communicate to his family that the court has ordered without any reservation that he be confined to home pending further order of the court. And let me just say one thing to you, young man. I don't know if you realize how deeply into this situation you are, or where you could possibly wind up if this thing goes south on you. You leave home and it comes to the attention of the court, you'll be back here and all the argument in the world is not going to get you out of here. You'll be on no bond. You are, when you bond, assuming you bond, you're going to go home. You're not leaving that property. You know, if it's a medical emergency and you're heading off to the hospital, that's an exception. Otherwise, you are at home. You are not to leave home. Understand?
Yes, sir.
Okay.
Your Honor, we would last no contact with co-defendant
Yep.
or any witnesses. No drugs, no alcohol,
Yep. Anything else?
no weapons, firearms.
No weapons. Okay. Well, so we'll do that, and that kind of resolves some of it. I mean, I'll be real frank with you. Had I reviewed this affidavit, I would have had a problem with some of that. But, you know, different people read differently, so, and you arrive at different conclusions, so. But that should take care of it.
Thank you, Judge.
All right. Thank you.
Good to see you.
Good to see both of you. It's hard to see people these days because of the mask. I had Mike Gibson sitting over there the other day, and I'm looking at him and I'm thinking, I think I know him, but until he walked up there, I had no idea who I was talking to. Yeah, so, thanks.
Thank you.
Wish you the best. Good luck. Did you get all that, Madam Clerk?
Yes. She's amazing. She gets everything.
Uh-huh.
I said, she's amazing, Madam Clerk.
Oh, she is. Absolutely. Unlike all the rest of them.
I didn't say that.
Yeah, you did.
That
You were
is
implying
not-
that.
That is not at all what I said.
I had Reynolds, Matthew Reynolds.
John, can we have a reset for tomorrow? I have some transport issues.
Yeah. He's off in parts unknown, huh?
I see Monday.
Right here.
Yeah.
What's happening?
I had what I got? I got another under county, Mary Deli's Cosme.
Look at you.
Yeah, it's 210000537. And
She bonded, Your Honor.
she did?
Yes.
Okay. How could she do that? She's got a failure. Oh yeah, she had a bond. So she had an out of county and a failure to appear. She bonded on everything, huh?
Yes.
Okay.
Okay, so Reynolds was reset because of what? Transportation issue.
Transportation.
Hey, football this weekend, man.
Saturday, tomorrow for a start.
You want your yellow piece of paper back? Nobody will read it up here. Hey, you guys.
Yes,
It's been a pleasure.
Bye. Have a good
We'll
one.
see you whenever they let you back over here.
They'll have it back at some point. So, it's been a pleasure. Good to see you.
Have a
Good
good
luck
weekend.
down there.
Have a good weekend, guys.
What's
Bye.
your vision?
It's right now 19 in front of Judge Roach right now.
Oh,
I like Judge Roach.
I like Judge Rose too, but I don't have to appear in front of him. Good to meet you. Good luck with all this. Just,
Bye.
just you know.
Okay.
That's the way to do it.
Okay.
Is that the last one?
That's the last one.
Last one, huh?
Probably not.
That was an interesting juxtaposition of issues right there.
We off record? We still on?
No.
No.
Well, we are.